Life conviction. Custody around 11 years. Lordship, death reference cases, state criminal appeal. Prisoner have been in custody since 18 years, last 18. We have filed an interim application for. My lords, I may pardon for mention, my lord. Double page number 6160 of 2024. The order rejecting my amendment application is subject matter before my lords. During pendency of the writ petition, now tribunal is proceeding with the matter, my lord. Another matter, my lord, is a 2011 case. My original application dismissed by the London Tribunal. I carried the matter before my lords. My lord was pleased to allow my writ petition, but applying the principle of Nityananda Barik as the matter was a reserved for more than by the London Tribunal, I remitted back the matter for adjudication. Tribunal again heard and allowed my original application. Pardon to make a mention, Lordship, the land has been acquired by IDCO, then handed over to a private company, but the compensation not has been paid.
Criminal appeal, my lord. Criminal appeal in custody for 10 years, my lord.
Pardon to mention, my lord. Item 15 and 20, my lord. On behalf of Mr. J.K. Ratha, his remained in his family, he's gone to attend 10th day, my lord. And another time. Which item? Item 15 and 20, my lord.
15
and 20.
15 and 20.
My lord.
Commendable. You're marking it because the other side is not present. So this adjournment you want it next week?
Next week, my lord.
Okay. We are marking it at the council.
Make a mention, my lords. My lords, item 44 in today's weekly list, my lords. My lords, I pray we'll file a rejoinder to the counter affidavit. I pray the matter may be taken up one.
There is interim order.
My lords, there is an interim arrangement.
Yes.
Obliged. Weekly list, item number 1.
Yes. That's it. May I please, Lord?
Yes.
Yeah. Annex 7, page 41, passed by the collector and district magistrate Bolangir under challenge, my lord. Lord, see at page 44, running page 4. May I please, my lord? The land acquisition officer Bolangir submitted that the superintendent engineer R&B division Bolangir intended to acquire the land pertaining to holding number so and so.
You are placing which paragraph?
That page 44, running page 4, the first paragraph.
Annex 7.
My lord.
Hmm.
Lordship, that
Yes.
the land acquisition, Lordship, see, I have been awarded with 4 crores.
Page 4.
Yes, my lord.
Running page 44.
Yes, my lord.
Yes.
I have been awarded with 4 crores 12 lakhs 47,603. But Lordship, see the column. We have paid only 3 lakhs 92,000. 3 lakh 92,000 64. 3 crores 92 lakhs 64,545.
Which you are placing.
May I? Yes, ma'am. And we start from the page 3.
Yes.
Third para. Second para.
Page 3.
My lord.
Yes.
43 on the page.
Yes.
The executive engineer Bolangir. On that.
Yes. I am placing it, yes. The executive engineer Bolangir RMB division had submitted that the suit land is recorded as agricultural land. Hence, it has been estimated accordingly. The land acquisition officer Bolangir has stated earlier that as per DCAC, District Compensatory Advice Committee, proposal submitted by the executive engineer R&B division Bolangir, the market value of Bahal Mamuli Kisam was fixed to 1 crore 37 lakhs 25,873 per acre, which was fixed upon the BMV and sales statistics whichever is higher. Accordingly, BMV was taken into consideration and the requisitioning authority has prepared the estimate amounting to 2 crores 8 lakhs 35,820, adhering to section 26 to 30 of the 2013 Act. The requisitioning authority has calculated the additional market value 12% per annum in estimate whereas he has not calculated the additional market value 12% while disbursing compensation amount to landowner. That's got it, Miller. Then, yes, next page. Yes, the land action officer.
Paragraph is
Yes, Miller. Yes, the executive engineer roads and building Bolangir and the land action officer Bolangir were directed to submit the estimated value of this land with proper and up-to-date calculation of interest. They were also directed to make necessary correspondence with the concerned department of Orissa. Yes. In the matter, the land action officer Bolangir submitted that the superintendent engineer R&B division Bolangir intended to acquire the land pertaining to holding number 100, plot number 1985, Kisam Bahal Mamuli, measuring an area of 0.75 decibel under Moja Bolangir Co. from Kumudini Behra and 3 others for construction of ring road at Bolangir town. Hence, the scheduled land had to be purchased directly from the landowner through bilateral negotiation. Accordingly, superintendent engineer R&B Bolangir has submitted an estimate amounted to 4,12,47,603 only by letter number so and so seeking necessary approval of the district compensatory advisory committee. The estimate was scrutinized and found that the same has been prepared adhering to section 26 to 30 of the 2013 Act, based upon the benchmark valuation, the sales statistics submitted by the district sub-registrar Bolangir. During preparation of the estimate, the benchmark valuation for the year 2022 and sales statistics for the year 2021, 22, 20 and 19 has been taken into consideration by the superintendent R&B division Bolangir. But in the table, the petitioners are, yes, as revealed from the comparative statement submitted by the requisitioning authority, the average sales statistics of preceding 3 years has been taken into account while preparing the estimate by the requisitioning authority, as it is higher than the current benchmark valuation for the year 2022. The estimate has already been approved by the DCSC accordingly. The executive engineer R&B division Bolangir submitted that they have prepared the revised estimate value of case land with proper and up-to-date calculation as per approval of the special secretary to government in works department Odisha, Bhubaneswar by letter number so and so, and the revised compensation has already been paid to the petitioner so as details given below. Lordship, prior to that, you also kindly come to annexure 1, my lord.
no.
Yes, my lord. Yes, yes, I'm sorry.
Stopping.
No, I'm sorry. Then the executive and R&B division Bolangir submitted they have prepared the revised estimate value of case land with proper and up-to-date calculation as per approval of the special secretary to government in works department Odisha Bhubaneswar by letter number so and so, and revised compensation has already been paid to the petitioner on 24/5/2023 as detail given below. Yes, you'll also see all the four. The
You complete, then you make
yes,
the submission.
the executive in R&B Bolangir stated the registration of case land has already been made in favor of government Odisha R&B department. Sufficient opportunity was given to the petitioners for submission of documents as per their claims, but the petitioner failed to produce any documents. Further, the petitioners are found absent on the date of final hearing, heard the LU Bolangir by Deputy Executive R&B Division Bolangir, and perused the other available records. I am to lead to the conclusion that the calculation of the compensation has been made correctly as per section 26 to 30 of the Act 2013, based on the approval of the Special Secretary Government in Works Department, Odisha, Bhubaneswar, by letter number so and so, and revised compensation has already been paid to the petitioners as per their claim. The petition disposed of petition the Advocate General Odisha Cuttack so and so.
So, what is your submission?
Yes, you'll also see page 44, running page 4.
No,
There-
if you come to
Yes.
paragraph number page 43,
Yes, Miller.
come to page 43, and second paragraph is very relevant.
Yes, Miller.
That
Yes,
is
sir.
internal page number 3.
Yes.
Please read that paragraph. The petitioners have further submitted.
Yes. The suit land is surrounded by 3 homestead land and adjacent to NS 26. Surrounded by numbers of educational institutions, nursing home, etc. So the presumption can be drawn that the land is possibly can be used in homestead. But while determining compensation, the acquired land is shown as Bahal Mamuli. While Bahal Mamuli instead of Ghoravari. As per the decision of the Honorable Apex Court in case of Anjani Moulu Desai for State of Goa and another reported in 2010, payment be made adding to 15% of the value of the sales consideration for year. Similarly, in case of Jogaram versus Union of India reported in 2017, Honorable Supreme Court has passed order that compensation can be determined by adding 15% of the value of the sales consideration per year, keeping in mind the escalation in price of the lands day by day. The petitioners allege that they have enacted the Tahsildar Bolangir several times for conversion of their land to, but Tahsildar Bolangir refused for conversion of the entire land at a time. he advised to apply for conversion of 5,000 square feet land at a time and so on. But the petitioner could not show in document application in support of the allegation.
In the ROR, it was recorded as Bahal Mamuli.
Yes.
And you applied for a conversion of the land from Bahar Mamuli to
Ghodwari.
And that was turned down.
Yes.
It is obvious.
No, it is turned down. It is pending, my lord.
Do not know, but when the
calculation
was made, it should be the basis of the entry that is there in the ROR. No?
Yes.
So when your conversion application has not yet been decided, it is to be under 8A of the
8A. Yes, yes.
And if any order passed against you, then appeal lies.
No, not against this order, my lord. Because pursuant to direction of this,
that conversion application has been disposed of or not, because it
conversion application is still pending, my lord.
Your submission, your counsel submitted that the Tahsildar Balangir refused for conversion. So that means some order has been passed.
Yes, you'll also kindly come to that Annex 1, my lord.
It's a very simple thing.
Yes, yes, yes.
Once you say,
yes, I'm placing. Yes, I'm coming.
You are right that once it is a homestead land, then obviously the
cost of
yes, yes. You'll also kindly come to that page 18, my lord, Annex 1. The land in question, recorded in the Kumudri Behra and others. You also got it, my lord. Page 18. No, you also page 19, my lord.
Your land someone acquire correction.
Yes, yes. You also page 19, my lord. I am land in respect of 1, 2, 3, 4. You also see that 4 plots are. It is yet to be converted to Ghodwari. And so for plot number 1879 by 7861 Ghodwari. 1981 by 7, so all the 3 cells are converted.
Plots they have acquired.
Yes,
it is not that
the equivalent is plot number 1985.
1985. That
is mentioned as and the total land was 1 acre 30 decimal out of 760 taken over.
Bahal Mamuli, upon your documentation, Bahal Mamul lekhaiji na nahi.
Yes, well, that is it. Yes.
Upon a application ଦେଇଥିଲେ conversion by 8A, right? But your council submission was that it was refused by the Tahsildar.
Yes.
Now you are submitting it is pending. So which one is correct? Whether that has been mentioned correctly in the order or some order has been passed and you have not challenged that order?
No, to that I will take instruction. So far that Lordship see 2013.
Once it is recorded as Mamuli, they cannot.
No, I'm coming to that, man. I'm coming to that.
Yes.
So far, the old accusation 1918 Act is not a complete act by itself. So legislation in its wisdom, the 2013 Act was enacted, and it is a beneficial legislation. You also see, keeping in view the value and locational importance of the land, determination is to be made by taking recourse to section 26 to 30 of the 2013 Act. You also see, adjacent to my land, that plot number 1879, plot number 18.
We have seen that.
Yes.
You say that nearer.
Since the land is adjacent to my land.
For that, a declaration is necessary or not?
Yeah, the declaration is necessary.
So then, if that has not been done by the time it has been determined, how can they will pay you at the rate of that Ghodwari?
I have got a decision to that effect. Once the land in question, which was taken over by the opposite party, keeping into locational important potential value. Photographed. I show it to Lordship.
No, we are not again. You are. We just want to know that whether your application is sub judice.
No, to that effect, I will take instruction. Whether no, this morning I was talking to the
just a minute.
My lord,
I will take instruction.
Keeping the act provides.
This is
not OLR. This is right to fair.
That is there.
2013
OLR back video.
Appeal right to sub-collector, I have examined. Refusal of application of 80 appeal right to sub-collector. Yes.
That is what conversion.
Section 30 order by the collector. Collector passed the order. Our
Sir, on the basis of the decision of Supreme Court, 15% enhancement करके दिया है.
Agreed 30 That is our sulative. That is agreed. That is a tribunal. As per the section.
That is what is tribunal. It's called.
1634.
reference to the authority.
Section 64.
Land acquisition.
64. Any person interested who has not accepted the dawah may, by written application to the collector, require that
For reference.
matter be referred to
For
the
reference.
by the collector for the determination of the authority.
64 man, section 64.
Yes.
Reference to the authority.
So here is a question. Here he has already accepted.
Accept.
No, that is one aspect. As we find that the entire thing is that ये जो साइड रो जतिक प्लॉट अछि ताकर केस से गुडाको सबु घरबाड़ी हिसाब रे येछि मोरी प्लॉट टा खाली मझिरे रहि येछि बहाल मामूल हिसाब रे तणु मते घरबाड़ी हिसाब रे आपण पेमेंट करियार थिला कंपेंसेशन.
Initially, they approached it before the honorable court in another data.
That was
directed for disposal again. Then the compensation amount was again more than the previous amount as per the bench valuation. Now the property those who they have, that is at the time of the taking it at the
right, that is
agricultural
to be
land.
determined. Is kisam ko type ro ଲେଖା ହେଇଛି ତାରି ବେସିସ୍ ସିଏ କହିବା କଥା ଯେ ଚାରିପଟ ଯେହେତୁ ଘରବାଡି ଅଛି ମୋରି ପ୍ଲଟ ଟା ରହିଛି ତେଣୁ
it depends on the as per the guidelines of the act.
That is why we asked him that.
And as per the act matter, if authority pass an order, they have to appeal at the authority High Court matter.
And the council made a submission there that it has been refused, but he is making a submission that it is pending. So
no, to that effect, I'll take instruction. You'll also see.
74
yes.
That is the cause of the issue. There is nothing.
No, one more thing, madam. Yes, one more thing I bring to lordship notice. Keeping in view the locational importance of the land and potential value. Adjacent to my land, all lands are except my three other plots they have already converted to Goravari. Knowing fully well the land is likely to be taken, that land was not converted under section 80 of the OLR Act.
We understand that aspect, we understand. But here the question
is
once it is refused,
I have been awarded with 4 crores. Yes.
Once it is refused,
yes,
then your status is different. That
yes.
Is what,
yes.
So you first take an instruction whether it is actually refused or pending.
Yes.
Then the status of your case will be different. Accordingly, will
yes.
Okay.
Yes, my lord.
It was also purchased by bilateral negotiation with the owner.
Yes, that is also one of the aspects, but that is not the thing.
I'm saying that in and around guideline issued by Government of India, even if it is for bilateral negotiation, 2013 Act will. And so far 2013 Act is concerned, 3-year preceding notification, the whatever benchmark valuation, and whatever
under section 58 na?
64.
Appeal 74.
OLR set actually. Yeah,
50. Appeal to
sub-collector.
Correct. Petitioners fight this.
No, may you are keeping next week with regard to that 8 application. I will take instruction.
Unless we give the
yes. I'm sorry. Yes.
Why we are mentioned?
No, I'm sorry.
That it would be easier for us.
Yes. It will be better. No, it will be better.
15 minutes time. Now it would be just go through that order. We can
yes.
If we simply
again to read.
Again, my lord, particular sentence that again reading just my lord.
Yes.
The petitioner alleged that they have contacted the Tahsildar Balangir several times for conversion of their land. But the Tahsildar refused to
that is what we are
next, my lord. He advised to apply for conversion of so and so square feet land at the time of so on, but the petitioner could not show any document to that effect.
Whatever. Let him obtain instruction. Let us give him that chance. The petition has been filed by the petitioners for setting aside public washing the order dated 5/10 2023, passed by the Collector and District Magistrate Balangir under Annexure 7, wherein the petition filed by the petitioner wherein it has been held that the calculation of compensation has been made correctly as per section 26 to 30 of the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013, basing on the approval of the Special Secretary to Government in War Department, Orissa Prefecture. And the revised compensation has already been paid to the petitioner for their claim. The Land Council for the petitioners or that the calculation has been made by the authority or determining compensation has been made in respect of the acquired land by the authority, taking into account that the land is shown in the ROR as Bahal Mamuli instead of Dharwari. And the adjacent plots, এটা କୋଉଠି ଲେଖିଛନ୍ତି ଆପଣଙ୍କର ପାରାଗ୍ରାଫରେ ଯୋଉ adjacent 4 plots have already been converted to Dharwadi. 43. However, so far as the petitioner is concerned, even though conversion has application has already been submitted before the Tahsildar Balangir, but no order has been passed there. And once the status or the kisam of the land is considered to be Dharwadi, the compensation amount would be at a higher side. On perusal of the impugned order, it appears that the Land Council appearing for the petitioners made a submission before the collector that the petitioners contacted Tahsildar Balangir several times for conversion of their land to Kisam, but Tahsildar Balangir refused for conversion of the entire land at a time, rather advised to apply for conversion of 5,000 square feet of land at a time, and so on. And the petitioner could not show any document or application in support of such allegations. Even in the writ petition, in paragraph number 4, it has been it is mentioned that the Tahsildar Balangir did not allow to convert plot number 1985 to Dharwadi, knowing fully well that the land in question will be taken over by the opposite party. However, during course of argument, the Land Council made a submission that the application for conversion under section 8 capital A the Orissa Land Reform Act 1960 is pending with the Tahsildar Balangir, which is contrary to the submission made by the Petitioners Council before the opposite party number 3. Also, the averments made in paragraph 4 of the writ petition. He seeks some, there is no dispute about that against the order passed by the Tahsildar. Appeal rights to sub-collector section 58A of the Odisha Lands Act 1960. The Land Council for the state has also pointed out section 64 of 2013 Act, which deals with reference to the authority in case a person present accepts the award can make a written application to the collector requiring him the matter to be referred by the collector for determination of the Land Council for the state submitted that in this case the petitioners have already accepted the compensation fixed by the authority. Be that as it may, the Land Council for the petitioner seeks for an adjournment till next week to obtain instruction whether the application under section 8A of the Orissa Land Reforms Act is sub judice before the Tahsildar Balangir or it has been disposed of, and if so, whether the petitioner have challenged the said order before the competent authority or not. Is this matter in the week commencing from 20th of August 2022? In the order next time.
Yes, Madam. It's convenient for us.
Yes, sir. ସେଥିପାଇଁ ଟିକେ ଡକା ହଉଛି ଖାଲିଟା କରିଦେଲେ
I'm
ପୁଣି ଆଉ ଥରେ 10 ଆଇଲେ ମୁଳୁକା. Yes,
I'm sorry.
okay.
Item 2.
My lord, item 2, I'm extremely sorry, my lord, I'm appearing on BC, my lord. Can I, my lord, to call this matter next week?
Okay. Any interim order?
Oh, there is no
No,
entry.
my lord, there is no interim order, my
Third time
lord. There
this
is no interim.
There's some difficulties. The Land Council for the petitioner seeks for an adjournment. The Land Council for ICICI Bank is present. Put up this matter in the comments from 20th of August 2020. Yeah.
Highly obliged.
Item 3.
This matter may pass over to tomorrow.
Yeah.
This matter may pass over to tomorrow.
Tomorrow is on. March 30.
Item 4.
My lord. The petition is a retired senior public relations officer of the establishment of railway. His prayer for promotion was allowed by tribunal. My lord, annexure 1, page 18. Order portion, page 24, my lord.
You are challenging which order?
My lord, I'm challenging. So, in the judgment was delivered on 7/8/2019. So, it was
come to the first impugned order. We go to our.
Again.
Please come to the impugned order and let us know what you are exactly challenging.
Again.
You are challenging annexure 9.
Annexure 9.
Right. Come to that order.
When my order was going to be carried out,
please place that order.
Again. Annexure 9. Page 36, my lord.
Yes.
In gist, the applicant, senior public officer, redesignated as a deputy secretary public grievance of East Coast Railway, alleging non-compliance of the order of this tribunal dated
the page number?
Page, my lord, 36, my lord.
Yes.
So, order, alleging non-compliance of the order of this tribunal dated 7/9/2019 in way number so and so, filed CP number so and so, for initiation of content proceeding in exercise of power conferred under section 27 of the so and so. The CP was listed on 31st/10/2022 when on the submission of the respondent that the order of this tribunal dated 7/9/2019 in way number so and so has been complied with, the CP was dropped. However, with the liberty to the applicant to proceed in accordance with law if he has any subsisting grievance. After a lapse of more than 1 year from the date of the order in CP, applicant has filed the instant MA 705/2023 seeking to recall the order dated 31st/10/2022 in CP number 7320 and rehear the CP since the order dated 7/9/2019 OA not been complied with in letter and spirit. Lord and Counsel for the respondents questions the very maintainability and sustainability of this MA filed after a lapse of more than 1 year without any application for explaining the delay and laches seeking recalling the order dated 31st/10/2022 in CP. This tribunal, while disposing of the CP, no doubt granted liberty to the applicant to proceed in accordance with the law if he has any subsisting grievance. On being asked, Lord and Counsel for the applicant did not it on the specific question raised by the Lord and Counsel for the respondent that an order dropping CP can be recalled through an MA filed after a lapse of 1 year. In view of the above, we see no ground to recall the order dated 31st/10/2022 passed in CP so and so through this MA filed after 1 year in absence of suitable explanation. However, it is made clear that disposal of this MA shall not preclude the applicant for availing the opportunity available to him under law. So,
When you just a minute, when an order was passed in your favor and for non-compliance you filed the contempt application, the respondent made a submission for the court that the order has been complied with. Why you said did not objected to the same?
my lord, yes, my lord. My thing is that Annexure 7, page 32. So order was, or my lord, major part of the order is being complied with. Se jo order ta Minister of Railway ro Annexure 6, page 31. Eta khali ମୁଁ ସେନ appear କରିନଥିଲି ଯୋଉନ CP was on board. Page 31.
ସେଟା ଲେଖା ହଉଛି କି ଯୋଉ issued order ରେ,
my lord,
you see the CP was listed on 31/10/2020.
ସେଇଟା ହଉଛି
Submission was made and that OA is complied with and accordingly it was dropped. So whether you are present or not present, matter has been listed. If you do not remain present, then what can be done?
my lord,
The submission was made. You should have remained present and said that if part of the order has yet to be complied, then matter would have been different. But you
my lord, little bit clarification with due respect, my lord. See jo compliance ta Annexure 6, page 31. The order is, my lord, Minister of Railway, in continuance of the board letter number so and so 17/1/2000, sanction of the Minister of Railway is hereby accorded to transfer two senior scale posts from traffic department to public relation cadre to promote Nirakar Das and C. Prafulla Kumar Mahapatra. Petition is Prafulla Kumar Mahapatra, page 31. In compliance with the order of the CAD, judgment dated 19. So, my lord, ministry has already, my lord, accorded my promotion, intimating to the general manager, East Coast Railway, my lord, Bhubaneswar. So, only they are to carry it out. Nothing else. Already it is being carried out. So, only a formal letter is required to be issued by the general manager, East Coast Railway, Bhubaneswar. So, when the matter was in session under the disposal of the general manager, East Coast Railway, so by that time CP was pending. So in this next page 32, so not for the applicant submitted that order of this tribunal has been complied with. Accordingly, CP is dropped. Notice issued are discharged. The applicant is at liberty to proceed in accordance with the law if he has any subsisting grievance.
Come to the operative part of that order, which was initially passed by the tribunal.
My lord.
That is 7/3/2019.
19. Page 24.
Page 24,
Uh,
paragraph
paragraph
number
12, my
Yes.
lord. For the reasons mentioned above, both the way deserves to succeed. Tests are directed to take appropriate action to promote the applicants in both the ways as per law, ignoring the order dated 4/5/89 of the Railway Board to decadre some of the post of senior PRO in violation of the Indian Railway Public Relations Department Group A and Group B post recruitment rules 1982. The way number 867/16, it belongs to me, are allowed to the extent as above. No order.
What was the direction to give you promotion?
Promotion.
That promotion has been given or not?
Promotion is given by the, my lord, the minister.
Whoever has been, it has been given to you.
Clarifying.
That order has been passed in your favor. So here is the question of contempt.
No, my lord. So, my lord, I am saying every officer, sir.
So then you will make additional that amount be paid. All
Then,
the order is very clear.
no, my lord, that I am not. Now, the general manager is saying that though we have received the letter from the railway board on 7/2/2020, some other formalities are required to comply further on the letter and spirit. So I say, in spite of the order of the tribunal.
Have you not yet been given promotion?
Yes, my lord.
Yeah.
I have not been given a promotion.
Yes.
Only this letter is issued. So when I asked to the general manager, as per the railway board instruction, please give me the promotion order.
Yes.
So they said that it is under process and it will take some.
This was passed in 2020, as you said.
20.
Annexure 20.
Annexure 6, page 31.
Yes.
Page 31.
That official promotion letter has not been issued in your favor.
No, my lord. This is my case. So so letter and spirit it comply hi nahi.
My lord. Yes, I am appearing, my lord. Lakshmi, there prior to that application, they filed another writ petition. That is WPC number 9413 of 2019. 9413 of 2019.
Yes.
That was disposed of on 22/5/2019. They have annexed it. From that record, I am saying, my lord.
Page 28, annex korchi.
Page 28. Mr. Mahantil and counsel for the petitioner wants to withdraw this petition. Since the petitioner is going to be retired on such and such 2019, 30th 2019, the court hopes and trusts that the authorities shall comply with the order passed by the Land Council Tribunal. So after this might have, because the first time it was listed, I don't have an instruction. This order has been complied with.
No,
against the interim, they come and file this writ petition.
Is that there is no official order yet to be issued that from such and such date, because he has already been superannuated.
My lord, yes, my lord.
2019.
That from the date of promotion till the superannuation, obviously he is likely to get that salary in that post to which he is promoted. But you are his grievance that the order is very clear. And the one authority has already passed the order, but the other authority is sitting over the matter. That is his.
My lord, this is my case.
So even if he has have to be given the
My lord.
So Mr. Pari just take instruction. He has to be as just promotion is to be given, and maybe some amount has to be disbursed to him. That's all.
Definitely, the Bureau and get them. The department must have filed the counter. There is not instruction after 10 days.
No, because once we say that process we adopt, then it is likely to delay further delay. If we just go on counter, etc., you just take instruction, and if you can, they can do it expeditiously.
Because on principle you have already decided. Your authority has already issued the letter.
Right.
Down to 7 is only to pass an order.
Right.
Yes.
All right. The a petition has been filed. The petitioner to set aside the order dated 23/4/2024, passed in CP number 73 of 2020, bracket A, which arises out of OA number 867 of 2016 by the Land Central Administrative Tribunal, Qatar. The Land Council for the petitioner refer to the order passed by the Central Administrative Tribunal under Annex is dated 7/2019, in which in the operative portion it is held as follows. Quote, paragraph number 12 at page 24. The Land Council further submits that since the order was not complied with, he opposed the tribunal in a contempt proceeding, and which was numbered as CP number 73 from 2020, and the on 30/10/2022, when the counsel for the respondent made a submission that the order of the tribunal has been complied with, the CP has been dropped, and the said order has been annexed to
Annexure 7.
Annexure 7. It is the contention of the Land Council for the petitioner that after passing of the order by the tribunal, who was that order that you are showing that order?
My lord, the annexure, say, my lord, annexure 6, page 31.
Page 31.
Open number 2 has Minister of Board, Railway Board, my lord.
Acha, Railway Board has passed the order on
my lord,
7/2/2020.
20, yes,
Under Annexure 6, wherein mentioned that the petitioner is promoted
our promotional post house Chief Public Relation Officer,
wherein it is mentioned that sanction of Ministry of Railways is accorded to transfer a senior scale post of Traffic Department of ECOR to PR cadre to promote the petitioner in compliance with the order of the Honorable CAT Qatar judgment dated 7/3/2019, and operation of the senior scale post department in PR cadre may be intimated to the Railway Board. It is the contention of the Land Council for the petitioner that in spite of the order passed by the Railway Board on 7/2/2020, the petitioner is yet to get any promotional order from the competent authority, and in the meantime he has already been superannuated. Mr. T.K. Padi, Deputy Solicitor General,
along with Mr. Guchayat, along with Mr. Deepak Guchayat.
Deepak, na?
Deepak Guchayat.
Land Central Government Council submit that they may be given some time to obtain instructions as to why the order passed by the railway board has not been carried out and the promotional order has not been issued in favor of the petition, even though more than 4 years already passed since the uh, passing of the order under Annexure 6. Mr. Padi, so we are taking it off on 27th, or you are getting
Yeah. 27th, yes, Your Worship, yes, sir.
or you want more time?
Little bit more time.
Okay, then 2nd September 2024, 3 weeks time. You are
Fine,
getting.
fine, yes, it's fine, ma'am.
2nd September 2024. Yes.
Obliged, ma'am.
Item 5.
May I please, Lords? Lords, this writ petition is under OJLS Act. In this writ petition,
Are you covered under Annexure 8?
this is covered, madam.
That you say. So what is your prayer thereafter?
My prayer is, my lord, direction may kindly be issued to the ASO measure settlement to record the properties as mentioned in my favor.
So that
Because
guideline has already been given in Annexure 8.
That is
My lord.
considered in
Yes.
terms of that. Okay.
my
Hmm.
This was brief form. Passing the order dated 23/2/1985, passed by the settlement officials in appeal suit number 6143 of 1985.
84
84 ଆପଣ player portion ने बोधे wrongly लिखे.
sorry, my lord, it is wrong.
84 तो
84.
4163 तो
4163 of
84.
1984.
अच्छा एटा कोन लिखिजंदी आपण देखंतु 6143 लिखिजंदी
Old thing.
এবং 85 लिखिजंदी so which is correct.
My lord,
आपण prayer देखंतु annexure 1 रो नंबर टा देखो total different है.
that is my lord 4163.
4163 of 84.
84. I will correct.
It's not अच्छा
4163 of 84.
आपण तम correction करियो कि एटा दे.
My
So उत्तर लिखो. The land council for the petitioner submitted that in the prayer portion, the appeal suit number has been inadvertently mentioned as 6143 of 1985 instead of 4163 of 1984, and he may be permitted to correct this. Correction करेंगे signature for the document. Paperless file. Then you file another copy of that hard copy upon file person to type for the prayer portion. Prayer for one. So it is further submitted that the case of the petitioner is covered by the judgment dated 2/1/2023 rendered by this division bench of this court in a batch case in WPC number 1608 of 2014. The Land Council for the state also accepts the submission made by the Land Council for the petitioner. Considering the submission made by the Land Council for the respective parties, who is to now decide this matter in terms of the order?
my lord, ASO measure settlement.
He is opposite party number.
He is opposite party number. My lord,
Two.
my lord.
Assistant Secretary you brought shall take a decision in terms of the judgment pronounced by this court. The land counsel for the petitioner shall produce the copy of the order along with the judgment passed by the division bench in the batch writ petition along with a copy of the writ petition before the authority within 2 weeks from today. On the receipt of the same, the opposite party number 2 shall communicate the matter. Communicate the order within a period of 3 months from the date of receipt of.
Item 6.
My plea, Your Lordship, my lord. My lord, this application is carried against the judgment of the learned tribunal, my lord, central cat, lord, against the dismissing my application for condonation delay because it was the original application was being filed.
Challenging the order dated
Yes,
31/11/2023.
Yes.
That is annexure.
Annexure, that is, my lord. 9, my lord. May I invite my lord stand up page 26, my lord, 26. The learned tribunal rejected on the ground my approach in delay to filing the original application. When, my lord,
What was your prayer in the first portion? You just read it out. Order of the tribunal, first paragraph.
Oh, read, my lord.
Page 26.
Yes, my lord. Quote in the present.
First paragraph,
my lord.
applicant son of so and so. Page 26, annexure 9.
Yes, my lord. That annexure.
Please read it out.
That the petitioner has moved this honorable court.
Mr. Counsel,
No,
why
no.
are you reading?
It's a, my lord,
Page 26, we are asking.
page 26.
Impugned order, what?
Yes,
is
yes.
it?
Oh, sorry.
Something else? Or
Yes, it is. Yes, yeah. Page 26. It is submitted by the learned counsel for the applicant. That
we are asking you to read paragraph number
First.
1.
First paragraph.
Paragraph 1. Page 25, my lord, that is.
No, 26.
No, sorry. That missing. Sorry. That page is. Yes, my lord.
Receive koriparunahanti.
Yes, 26, page 20 is applicant son of late
Yes.
Artha Balavantarai, who while working as head trackman under such and such retired on superannuation with effect from 30th June 2002, has filed this way seeking direction to the respondents to release the arrear salary of his father for the period from 1st December 1999 to 30th June 2002, and also to provide employment to him.
Now you come to the operative part.
Yes.
Why it was rejected?
In paragraph 9, in view of the facts and law discussion above,
paragraph
8.
in P.K. Ramachandran versus State of Kerala and another year 1998 Supreme Court 2276, the Honorable Apex Court, while considering a case of condonation of 565 days, wherein no explanation, much less reasonable or satisfactory explanation for condonation delay had been given, held that law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when the statute so prescribes and the courts have no power to extend the period of limitation on equitable grounds. Then 9. In view of the facts and law discussion above, we are not inclined to interfere in the matter at this belated stage, since it failed to sufficiently explain the delay. Hence, the MME's application is rejected. Resultantly, the original application stands dismissed on the ground of limitation.
You have virtually approached the court
Yes.
after 21 years.
So that, as per the tribunal, my humble, my humble submission, my lord, that my father, this is employee, he expired, as per the death certificate, he expired in 2010, my lord. Thereafter, the wife, my mother, my lord, she persuaded the matter with the authority before your lordship's annexure. And thereafter, my lord, during intervening period, outbreaking of COVID-19, I immediately, the husband, son, my lord, I filed. I explained all the things, my lord, that my father has persuaded. Thereafter, my mother in harness also persuaded that this is, my lord, only. And, my lord, the learned tribunal.
Let us see the copy of the original application.
That's why I was not annexed, my lord.
Very important.
Sorry.
Said that you have explained it in a very nice way. Not that how you have explained.
I have not annexed. Sorry, my lord.
That is the crux of the matter.
Yes,
that ground it has been.
my lord. I
So
bought
file that original.
Yes.
Look on the petitioner has challenged the order dated 21/11/2023 passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, in original application number 700 of 2023, and for a direction to the opposite parties to release the arrears salaries of his father for the period from 1/12/1999 to 30/6/2022, and also to provide employment assistance to the petitioner in any post suitable to his qualification on compassionate ground in the interest of justice. On perusal of the impugned order under Annexure 9, we find that on the ground of delay in approaching the tribunal, the OA has been dismissed. The arrear salary of the father of the petitioner for the period from 1/12/1999 to 30/6/2002 was claimed in the year 2023. The Land Council for the petitioner submitted that in the original application, the petitioner has explained why there was such an inordinate delay in approaching the tribunal. However, he has not annexed the copy of the original application and seeks some time to file the same.
Original application and miscase.
And miscase for combination of the miscase. Okay.
MA 661.
Put up this matter.
Let do 1 week time. Next.
1 week time. Put up this matter in the commencing from 27th of August.
I'm failing to coherence.
Appearance of been noted.
Mr. Padi, Land People's Solicitor General, how can na lekha hogi?
Udit Ranjan Jana. Along with Udit Ranjan Jana. You are Jana. Udit Ranjan.
You are Jana.
Yes.
Item 7.
May I please, Your Lords? My Lord, on 2/7/2012, the National Highway Authority issued notification for acquisition of for expansion of the National Highway. They invited objection. I filed objection under Annexure 1, stating prior to that notification, I had filed civil suit against the state government, and that suit has been decreed. Judgment has been passed in favor of mine, and decree also passed under Annexure 2. That
No,
is
you have received compensation?
No, not yet. The state government preferred first appeal, thereafter second appeal.
When it was acquired?
That has been acquired in the by notification 2/7/2012.
2012.
Yes.
So what you are doing for this 11-12 years?
In that period, I have filed objection furnishing all documents in my favor, including the judgment of the civil court and decree.
No, is there any document to show that the particular land which has been acquired by the authority stands in your name?
Yes, right title, the right title interest has been declared by the suit.
A civil suit.
Yes,
Whether that is order dated?
order dated, that is prior to the notice, 21/11/2011 under Annex 2.
So no appeal has been carried out against.
Preferred appeal, lose, again second appeal, lose. In December 2023, they preferred appeal and they lost that appeal.
Where is that order?
That Annexer 9, second appeal.
No, second appeal is
Preferred by the state authorities.
that is
Annexer 8.
So that order was passed on 29 to 2024. Recently it was passed.
Yes.
So what happened in that?
I said all these documents by submitting representative under Annexer 9 on 20.
Appeal dismissed, second appeal dismissed. Okay.
Yes.
That is page number 61, right?
Yes.
In view of the all aforesaid, the substantial question of law is thus answered against the appellants.
Yes.
That the defendant in the appeal stand dismissed.
Yes.
Okay. So now.
Thereafter, I submitted all these documents before the National Highway Authority.
This order was passed on 29 to 2024. Then you made a representation
under Annexer 9.
So till date you have not got any response.
And they
want the disposal of this representation.
And they are going on carrying on the. They have already excavated the land.
So it's all right now. Perhaps unless they go to Delhi, now there is no problem, as you said. The writ petition has come back. The writ petition has been filed by the Chandra Ashram. It's a prayer.
Anupula Chandra.
Your petitioner's name is Akula or Anupula?
Akula Chandra Ashram. Represented through its Marfadar Kirot Kumar Mishra.
No, but in
Akulata ঠিক না অনুকূলটা ঠিক?
না Akula.
রিলাই করছেন তাদের লেখা আছে অনুকূল।
ସବୁ অর্ডারে লেখা আছে অনুকূল চন্দ্র।
ওকালতনামা কোন সাইন করছেন? ଆକୁଳ ଲେଖିଛନ୍ତି
ଆକୁଳ ଚନ୍ଦ୍ର ଆଶ୍ରମ।
ଆଉ ଏଠି ଗୋଟେ କଣ
ଡକୁମେଣ୍ଟ
64 years
ଠାକୁର ଅନୁକୂଳ ଚନ୍ଦ୍ର ପୁରା ସବୁଠି ଆପଣ ଡକୁମେଣ୍ଟ ବି ଅନୁକୂଳ ଚନ୍ଦ୍ର।
ଆଜ୍ଞା
ଆଉ
ଆକୁଳ ଚନ୍ଦ୍ର ଆଶ୍ରମ କୋଉଠି ରହିଲା?
ଅନୁକୂଳରେ ନାଇଁ ଅନୁକୂଳ ଅନୁକୂଳ
The petitioner so answer through Marfat Dar Kirot Kumar Mishra has filed this writ petition with a prayer for a direction to the opposite party to release due compensation along with accrued interest toward the acquisition of the petitioner's land and the plot number so on the criteria the prayer. The land council for the petitioner submitted that after the judgment was passed, after the judgment was pronounced by the Land Civil Senior Division. The co-division coach anymore?
Civil Judge Senior Division
in CS number 1, annexure 2, which is one, so in his favor, with the direction. Operating part of CS number
37, 38. This would be some
Page 38.
The order that the suit was decreed against the respondent, the right title, interest, and so on so plenty over the said land was declared. and the plaintiff's position over the suit land was confirmed, and the defendants were sworn, so the opposite parties are conjuncted from interfering with the position of the plaintiff over the suit land. The opposite party number one preferred RFA number one, so that is annexure 7, which was dismissed on the ground of limitation by the London District Judge Cutter on 14/7/2017 in RFA number 1. The said order was challenged by the opposite party before this court in RSA number 453 of 2017, and by judgment and order dated 29/2/2024, the appeal was also dismissed. The London Council submits that the petitioner preferred two representations, 28/6/2024 and 29/6/2024, before the authorities, that is Project Director NHAI, Denkana, that is opposite party number 2. 2, so it was 1, opposite party number 1.
1.
Okay. For the purpose of getting compensation, but till date he has not received any response from the opposite party number 1, and the direction may be issued for disposal of the representation expeditiously by the said opposite party. Current counsel for the state has no objection to such prayer, considering the limited nature of so the opposite party number 1 is directed without expressing any opinion. Opposite party number 1 is directed to consider the representation submitted by sworn under annexure man and dispose of this in 3 months from the date of production of the certified copy of the order. Copy of the writ petition and order be communicated to the within 2 weeks of taking the
Requisition.
Yes.
And this is central government, not state.
NHAI is central.
Because the competent authority appointed by the central government.
The he appear करना थी.
कॉपी के लिए हमको तो सर कर दी.
अच्छा, in transfer per in view of no, there is no necessity of issuing notice for limited nature of their. Okay. They have no panel council.
Central government council.
National, I think National Highway or panel committee. I don't know Mahanti.
Your theory copy the Mr. Mahanti. Phone number अच्छी. That contact कौन से तरह से अच्छी वजह से उतना नाटा लिखी दो. Yes. Yes, next.
He is the associates.
कहाँ रहो?
उमेश चंद्र महांती.
अपन को सारन को ना लिखाई है जी, खाली रिप्रेजेंटेशन डिस्पोजल होता ना रे. उमेश चंद्र महांती ना, तंगुर कॉपी दियो ना. इसको देखिए. Yes. Has no objection. Yes.
Item 8. And next week.
Next week.
Item 9.
9 is similar to item number 7. Where Firod Kumar Mishra is the one.
Separate.
And same
item number 7 jaha hala
खाली number ura change
number change of the case number
plot number.
Dispose of live item number 7. Yes.
Item 10.
In item 10, my lord, the petitioner, the widow lady, my lord, challenges the order under Annex of 7 and 8, wherein the Indian Bank,
has issued notice to take possession of the property of the present petitioner, as well as basing on the false affidavit submitted by the bank authority before the Lionel CGM Khordha under section 14 of the Securitization Act. The Lionel CGM Khordha under Annex 8 directed to take possession and sell the property by using the police force. The husband of the petitioner has run a business, namely battery center at Kotak Road, Mumbai.
You have come against the order under
Yes.
So why will entertain? Why are you not
The Lionel CGM has passed the order. Lionel CGM Khordha
Yes.
has passed the order by appointing one person as a
No, there is no other alternative remedy
there is no other
against this order. Mr. Sahoo?
Section 14 is also coming under the ambit of section 13.4. So it is a DRT.
And my submission, they have
Yes,
not issued any notice under section 13.2.
State of Maharashtra judgment is there and noble.
Since they are going to,
he can approach to the
possess the coconuts from their
Once the alternative forum is available before the DRT, so why will entertain this? That is the crux of the matter. We are not entering into the what has happened on merits of the case. Same thing you can approach and say before the authority.
Since the bank authority has giving a false declaration that they have served the notice upon the petitioner under section 13.2.
Whatever it may be, can you not bring this thing before the DRT? That is the Sahoo is telling that.
State of Maharashtra, MS
Kanala and
novel.
Some interim protection may be given. Given at 2 weeks time, so some interim protection be given. Otherwise, they will.
Yes, and alternatively, this is MOD is able to upload the authorities. Yes. Duna Sahoo is present on behalf of Indian Bank. Yes.
Some interim order may be given. No corrective action.
Maintainable. How can we pass interim order? Once we say that you are to approach and seek for any order you want.
Item 11.
Please, my lord. My lord, here, my lord, the petitioner, he also retired Naik, who was also serving under the Corps Battalion and retired from service in the year 2005. Pursuant to the state government notification, by the notification number 19513 dated
presentation 4 series.
Sir, 4 series. And that has been given February. Yes.
It latest house February ta purbo guda bi sab deichan.
Agya.
11/12/2023 6/2/2024
Sir, yes.
Authority same to collector.
Yes, collector as well as the tahsildar.
Under annexure
4 series
to be disposed of by so and so. Breaking the time limit fixed up for 3 months from the date of production of this one. So, in order to be communicated within 2 weeks from taking of this. Yes.
And here in case the University formal party Soluchana is appearing, Soluchana Patra is appearing, and name.
The Union of India.
Soluchana is appearing in the office.
You are appearing for then opposite party number 2. So Mr. Parika.
Soluchana Patra. Miss Soluchana.
Yeah.
Item 12.
Madam Appellant, report this rate appeal challenging this honorable single judge who has confirmed the
Who is appearing for the other side? Prashant Kumar Apanda.
Counsel for the endowment, Mr. Nath appears.
Mr. Nath is for
Naidu is also.
Naidu is there. So many orders have been passed previously.
My lord, in this case, my lord, I have filed 3 IS, my lord. Sole appellant died, my lord. So substitution, one is substitution petition and one is abatement and another is a limitation petition.
So is there any objection from the other side?
Copies have been served.
Yes, yes. ହଁ ଗଲା ଥର ଦେଇଥିଲି ଲାଷ୍ଟ ଯଦି କହୁଛନ୍ତି ଆଉ ଥର ଦେଇଦେବି ଆଉ ଥର ଦେଇଦେବି କିଛି ଯାଏସି sole appellant died.
Counsel, you have made 4 respondents in this.
Yes, ma'am.
So the copies, all the respondents are entitled to get your copies of interim application.
Yes, ma'am.
But
yes.
Notifications have not disputed whatever my landed my lordship passed. The main application.
Main application I will serve. Nashima allow the substitution and
this Krishna Chandra Padi seems to be the main appearing for him. Prashant Kumar Panda is not there. And then another person, also private person, is there, Subhash Chandra Bisoi. You have challenged the order of the land single judge passed in
WP
2912.
Yes, my lord. Yes, my lord.
Now, who has died according to you?
Chaudhary Bharda Rajulu Reddy, appellant.
Application is for substituting the applicant so and so P75 and
Setting aside abatement
and also condonation of delay. Right. First condonation of delay. 2010 no objection, serious objection raised from the side of Swancho. Opposite non appears to opposite party number. We tap to Prashant Kumar Panda.
Sri Krishna Chandra Padi. Krishna Chandra Reddy. Krishna Singh Reddy.
Padi.
Krishna Singh Padi.
So, delay condone, amendment set aside, and this prayer made in this interim applications regarding substitution is allowed.
Yes,
so you have to file a phrase
consolidated within 15 days.
15 days, 2 weeks. Copy is to be furnished
Yes.
to the Land Council for all the respondents. Yes.
Obliged.
Item 13.
Counterfeit delay condemnation of
IA is there for restoration of the
objection, if any.
Any objection you filed or you condone?
Yes, so the oral objection we raised, my lord, 365 days, 365, almost 1 year, man.
Filed for restoration for recording the order dated 17/8/2022. Passed in WPC number, Federal Elections W62.
5112 of 2013.
5112 of 2023.
2013.
Which was
13 or
dismissed, 2000, which was dismissed for non-prosecution as per order dated 17/8/2022. The staff reporter has pointed out that there is delay of 336 days in filing this CMLPA. 36 days. The Land Council Mr. Dayanand Mahapatra and Council appearing for post to the application for conversation of people, considering the submission made by the Reliance Council for the respective party and going to the governments taken in the interim of petition. In filing the CMAPL is confirmed. IA is disposed of, then CMAPL is for action. So it is restored.
Not shipment direct the read to be so that it can be disposed of.
Which one?
Read.
It is to be listed on the assigned bench first. Assigned bench only.
Item 13.
My lord, this is the matter. The petitioner didn't qualify the last district judge because of his falling short of 3 marks.
Yes.
My lord, the petitioner didn't qualify for the post of district judge because he is falling 3 marks short for the qualifying marks, my lord. When the RTI document comes, my lord,
Last it was taken up by Malot from 5/3/24.
It is pointed out that she is entitled to get 3 more marks. Okay, as for the answers which have been provided to her. Whatever it may be, you just file your counters. So we are putting it down 27 in the meantime.
Yes,
And then council for the state. 2 weeks time. File the council with this matter meeting from 27 of that meeting containing
Item 15.
Pardon, my lord. In this case, I am appearing for the opposite parties, my lord. The first matter, I sent to file my counter affidavit, my lord. I late contacted with the clients very recently, my lord. And after instruction, 2 weeks time.
Appearing for the petition.
Yes, sir, Mr. Jayant Rathi. Mr. Jayant, Senior Counsel, Mr. Jayant Rathi is appearing.
Actually, he was seeking. All right. A mention is made on behalf of Senior Advocate Janet Marco to adjourn the matter. The current council appearing for
Opposite parties, my lord.
opposite party.
Rest of the participant, I am appearing from opposite party number, my lord, 2 to 14 units. 2 to 13. 2 to 13.
Current council parties and council appearing for opposite parties number 2 to 13.
My lord.
Is for an adjournment. For filing counter
Matters.
of this matter.
2 weeks time, my lord.
This matter from 2nd September 2024
Both the matter, my lord. Both.
The WCC number
123 of 2008.
Item 16.
Item number 16, Mr. Sarangi, is your case.
My last occasion, I learned senior Mr. Das.
There is nothing, no instruction would be required. Only thing is if that committee is still, I have instructions that it is no longer functioning.
15 କିଛି ପାଇଲା ହିଁ civics to social media. Come from
If your lordship calls it after a week or so, after 10 days it may be called, let me take instructions as to what has happened.
as per instruction से community नहीं.
We are 27th or second?
Second.
Second.
Second. You are appearing for which?
Open of 5.
For Lord Lingaraj. Trust board.
Lingaraj submission is that matter to be taken up after 2 weeks.
Published.
Attorneys present in the application, including this matter.
Second.
Published.
Item 17.
May I please, Your Lordship? Here, Union of India has challenged the order of Land and Central Dispute Tribunal, my lord.
Which for the other side?
I'm for the other side.
You are for the. So which order you are challenging?
Challenging the order, page 63, start from 63, madam. Here the opposite party number 2 and 3. They were opposite parties. They were engaged as casual.
Just read the first paragraph of the order. Page 64.
64. The applicants in the present way were working as casual lighting assistants, otherwise designated as camera assistants at Doordarshan Kendra Bhubaneswar at the time of filing of OA. In this way, they have prayed for the following relief: to pass the order dated 7/5/2004 and 1/7 under Annexure A11 and A14, to direct the respondent to extend the benefit of memorandum under Annexure A2, A3, A4 to the applicants as extended to other similarly situated lighting assistant in Doordarshan Kendra, and pay the differential area dues retrospectively, to direct the respondent to pay the applicants in revised tariff as amended, to direct the respondent to pay the applicant's interest on the area amount, to pass any other orders.
Okay, what happened operative part?
Yes, ma'am. Before that, Your Lordship,
Yeah. Come to that.
Yes, ma'am. That is in
What do we?
page 72, para 13.
72, para 13.
In view of the fact that applicants are rendering the same kind of work as that of casual employees awaiting regulation under schemes of 1992 and 94, and going by the principles court in a number of judgments which incontrovertibly establish the principle of equal pay for equal work, I am inclined to accept the contention of the applicants that their wages should be enhanced and they should be paid equal wage as that of others who are covered under the scheme of regulation of 1992 and 94. Accordingly, the impugned orders dated 7/5/2014 and 1/7/2015 under Annex A11 and A14 respectively are passed and set aside. The respondents are directed to extend the benefit of the memorandum under Annex A2, A3 and A4 to the applicant. Orders to the effect may be passed within a period of 8 weeks from the date of receipt of this order.
Just clear. Yes.
My lord, these two opposite parties, they were appointed to assist the cameraman to and operate lights during the shooting of program Lokomancha in the year 1992 and 94. Your lordship, that is available in page 33 and page 34 of the brief plan. Subsequently, they were continuing subsequently in 2015. Your lordship, that is at 35, page 35.
No, what is the nature of their appointment?
They were that has been mentioned to assist the cameraman on the location. Page now 33.
Casual employees.
Casual employees. To assist the cameraman, that is there.
33 double 33 or 34?
This is a period from 5792 to 6792. And thereafter in page 34, to assist the cameraman on the location shooting at Talchep from 25/10/2092 93 to
if I switch page number 33 Tauchi Gautam
1, the opposite part number 1.
Okay, opposite party number 1.
And that 34 opposite part number 2.
Okay.
Then just next page, my lord, page number 35. They were on 2015 to work as lighting assistant on assignment basis 10 days for assist in camera unit work at DDK Bhubaneswar as per court instruction. That means they were continuing as per the order of the Honorable Court. Again, in page 36 also, same, to work as lighting assistant on assignment basis for assisting the camera unit at Bhubaneswar as per instruction, as per court instruction. Your lordship, they are governed under, your lordship, may turn to page 26. 26 annexure A by page 26 of the brief. This memorandum was issued on 25/8/2006. Your lordship, Romanic 2, lighting assistant, oblique lightman. They have been paid rupees 389 per day. Now what happened, my lord? Your lordship may turn to page 28. Here, on 30/10/2011, my lord, your lordship, in continuation of Director Memorandum dated 2/9/2011, the understanding is that to convey the sanction of the competent authority for revision of amount fee will be payable to the casuals engaged in various Doordarshan Kendra on casual assignment basis who are awaiting for regularization under Regulation Scheme 9692 917/3/1994. Your lordship, may pause here. Your lordship, this notification is only applicable to the persons who are awaiting regularization as per the scheme of 1992 and 17/3/1994. Both the opposite parties are not coming within the ambit of this notification. There is no dispute. It's admitted fact. Again, thereafter, page 30, my lord. Page 30, that is the memorandum dated 12/12/2012. Here, the competent authority has approved the revised fee structure of the various categories of casual assignees, which are applicable for regional news Doordarshan Kendra, along with a new rate card are as follows. Here, my lord, there is no post like lighting assistant. At serial number 17, camera assistant, that has been revised.
from rupees 330 to rupees 750. They are claiming thereafter, my lord, on 22/3/2000, your lordship, page 32. The undersigned is right to convey the sanction of the complaint 3 for revision of amount fee payable to the casuals engaged in various units to meet programs exigency on casual assigned basis who are awaiting for regulation. Again, your lordship, this memorandum is also for the persons who are awaiting for regulation 92/93, the revised fees. They are the lighting assistant, lightman, that has been revised from 532 to 840.
No, what is that scheme?
The scheme is the persons who were continuing earlier, my lord. They were earlier means
from you annexed that scheme.
No, that is not dispute in this case, but they are only asking here. The dispute is, my lord, they are only asking that we should be paid at par with these persons.
Okay.
That is their that was allowed by the.
So why is it being denied?
Because of, my lord, they are first of all, they are not the camera assistant.
No. It is the nature of the assigned,
Yes,
that determines, not your
for that
nomenclature in the
yes, for that
notification.
purpose, your lordship may turn to may have a glance over the order dated 27/7/2022. 27/7/2022.
No, page?
Where I was asked
Page?
No, order sheet.
Hour.
It's honorable court, sir.
27/7/2020. Okay, it is mentioned Mr. G. Mahathir, senior panel, Sanjay's government council on the text of the nature of work discharged by the cameraman and also the lightman.
Here they are saying that
they are lightmen.
They are lightmen. They are not the camera. Here they are saying that we are assistant cameraman. There is no such post like assistant cameraman. Here, for that purpose, we have filed an affidavit on 26/10/2022. There we have given the nature and scope of work.
Lightman boli kichi ye nahi.
So the scope ta deju ta lightman ro kamo kon, camera assistant ro kamo kon. That is that was filed on 26/10/2022 by way of an affidavit. The lordship 26/10/2022 the affidavit.
Affidavit dated
26/10/2022. Your lordship, we have annexed the page 3 re cameraman date 2. This the scope of cameraman, and next page 4, lighting assistant. These are the scope. Now their claim is that this light assistant has been merged with camera assistant. That means we will be calling as, they will be called as cameraman assistant, which is not a fact. Therefore, they are governed under
the lighting assistant.
Yes.
Page
77.
Column number 2 tar hoichi.
But that notification is for the purpose, the persons who are awaiting for regularization. These persons are not awaiting for regularization.
That is your distinction. That is your distinction.
No, that notification is not for them.
No, all right, but the nature of duty is same.
Nature of duty, lighting assistant, but that before that they are asking for 750. Your lordship, page 28 are there. They are governed under page 26, 25/8/2006. These persons are paid according to this memorandum.
No, ସେମାନେ ଖାଲି ଯେ ଲାଇଟ୍ କଥା ବୁଝିବେ ସେ କଥା ନୁହେଁ। ଆପଣ ଯୋଉ ନେଚର ଅଫ ଡ୍ୟୁଟି ଆପଣ ଯୋଉଟା ଦେଇଛନ୍ତି by way of an affidavit in pursuance of the order dated this court, that also indicates that the ସେଟା
76, 77.
ଯୋଉ affidavit ଟା ଦେଇଛନ୍ତି ଏବେ ଯୋଉଟା ଦେଖୁଛି ସେଠି गोटे रहुची lighting assistant रे the operation of different type of lighting arrangement as an outdoor location, so and so. Assistance to cameraman in loading and uploading of film cameras.
Pilot.
Storage and maintenance of equipment under a charge, any other related duties. So
They are not the camera assistant. The camera assistant post is earmarked, my lord. That I have shown you, let's say.
no, plain and simple. It indicates that cameraman is something different, lighting and
Yes, that is a nomenclature that you have shown.
Camera assistant,
Nature of duty
your lordship
is
may turn to page 30. Serial number 17 ने camera assistant पूरा लिखा है. That post carries.
कितने number?
Page number 30. Serial number 17. The camera assistants, Puraj, they are claiming 750 per day as per camera assistant. We say they are not the camera assistant.
ताले ये जो heading रे जो post गुड़ाक रही या देरे अपन करो ये जो light assistant पर ये टकाएं
नहीं पर
नहीं
तो उठे दले
shooting केम दिया हुआ
25,000 दिया notification से जोटा page 20 देखे लिए अपन को.
Now who are doing that? Who is assisting for the lighting and all that? You have removed the post, that's all right. But somebody is doing it.
Not removed.
Then
we have been continuing, but they are governed by the
notification. No, what is the post of lighting, sir?
Assistant. Lighting assistant like that.
Good.
Page 26.
No, page 30 as you said. What is it?
30 is a fee structure. 30 is not that.
There must be a fee structure for the light, assistant lighting.
It's about 25/8/2006. Page 26.
No, not like that. Can a shooting be held without the assistance of camera?
No. That is also not my submission.
So, camera रे जेतिकी दरकार, lighting रे मध्य सेतिकी दरकार, so समस्त में coordination है कि नहीं के shooting टा हबो. तेणु आपण ये जो post गुड़ा को आनी ले ताको total light assistant को total नहीं गले.
नहीं lighting assistant पा अच्छी चपते भी continue करचुन से ना. 25/8/2006 अनुसार लाइटिंग असिस्टेंट अच्छी एगुडा फी स्ट्रक्चर टा सेपरेट हेतला जोटा कि कैमरा असिस्टेंट को केते हो लाइटिंग असिस्टेंट को नहीं आइन दे हैव बीन कंटिन्यूइंग बट देयर फी स्ट्रक्चर इज नॉट कैमरा.
So what is the extent of wages the counterparts are receiving? Those who are likely to be regularized.
जोटा annex करचंदी आपनकर affidavit पे that is the duty of a cameraman.
Yes,
cameraman is something different than camera assistant. So what they say that camera assistant and lighting assistants रो जो duty यदि हमें compare करी वो ताले to seen that almost similar.
Yes.
अपन इटी जो space करचंदी that's a duty of the cameraman. Cameraman is something different. Camera assistants wrote kamata count.
Their case is the lighting assistant has been merged with camera assistants. Say there is no such notification to that effect. That is my submission.
What is the when you are you post upon a camera assistant? देखा तो तेरा chapter number page.
Set out
30. Serial 17.
Camera assistant आपण काहा को कहउछंती तार काम कोन
assisting the cameraman
कोन काम कोन
लिखा है सर को
ताले लाइटिंग टा भी मधे असिस्ट करिवो ना कैमरा को
लाइट असिस्टेंट तो केवल कैमरा
जेता गोटे पोस्ट क्रिएट करिसंती एवं तारो दरमा या लिखचंती तारो ओल्ड स्केल या थिला तारो रिवाइज्ड स्केल या थिला तो प्रत्येक पोस्ट पई तांकर कोन काम
एथरे डिफरेंस हो जो लॉट्स आ गोटे पॉइंट छाटी 8 जो अच्छी your lordship at page 30 fast कर दो. has approved the revised fee structure of various categories of casual assignees. Categories of casual assignees which are applicable for regional news units. That means these persons are of the regional news unit. But your lordship may see 25/8/2006 page 26. These person casual assignment basis, casualties for various Durdarshan Kendra. These are these two persons are different. Here they are engaged by there they have been engaged by the regional.
Once we find that this nature of job of a camera assistant is almost identical to this lighting assistant, then it justified that it has merged to that. You have taken away that lighting assistant. Now you have redesignated it as camera.
No. In 2012, we have said lightman. Your lordship may then turn to page 32. The lighting assistant has not gone. Your lordship may page 32 us. 22-2013 जो तो lighting assistant lightman अच्छी. But this notification is for the persons who are awaiting regulation.
So separate set of persons are there for lighting.
Yes, fine.
Separate set of persons are there.
Separate set. These persons are engaged by regional news unit, and the opposite parties, they have been engaged by the Durdarshan Kendra. That is different. And casual assignee, these persons are directly engaged by regional news unit. Therefore, the posts are different. Therefore, their payments fee structure is something different, and this fee structure is something. That merge, just so far as merge is concerned, that is not there. Lighting assistant is very much available. And 2013, the lordship is say lighting assistant lightman is there.
But once you see the initial appointment order, that is on page number 33, what you point out, it is not only to assist the light, but also to assist the cameraman.
But subsequently, that has merged with the order appointment dated 4/2/2015, Lordship. 4/2/2015.
And that is what is their case. That is merged. But the duties are there.
4/2/2015,
to work as lighting assistant on assignment basis
or assisting in camera.
Yes.
So again, it comes to that it is their role is not only making the arrangement, etc., but they are to also assist in the camera. They are to work as the camera assistant. So that order makes it very clear.
But merger is not there. Camera assistant is something different. Just to us.
This type of in the title while issuing the this appointment or continuation, whatever it may be, that order, that is very clear that their responsibility is dual in nature. They are to work as lighting assistant on assigning basis and for assist camp. So that is exactly what they say, that they are assisting the camera unit, means they are camera assistants. They are camera assistant जो माने कैमरा को हेल्प करिवे विभिन्न लोकों को विभिन्न प्रकार काम दिया जाइछि. तो किए साउंड इफेक्ट को कंट्रोल करथिबो, किए लाइटिंग को इफेक्ट करिवो, बट दे आर ऑल assisting to that camera image. So they are camera assistant. So why are you making a discrimination between the two?
That whatever assumption I had to make at.
Yes. And the only point where you are differing is it is for those who are likely to be regularized. That is the basic.
Yes, ma'am.
Otherwise, on the nomenclature, nature of duties, you have nothing to say on that. Technically, you are saying that the pay structure is meant for those who are likely to be regularized.
And
after 1990 to 1990.
They are appointed by RNU.
So that is
regional nature.
But nature will pass on.
Okay. Any other submission?
No.
Yes, what do you say?
My contention is that the land tribunals correctly observe the award pilot, the order pilot, after observing all these six pilot, the present opposite party number 2 and 3 are 1 and 2 are working similar nature for pilot. Under page 30 memorandum, that presently what the present opposite parties are seeking, my lord. Initially, they are the petitioner in the tribunal before the tribunal, my lord. That the rupees 840 lighting assistant light lights. That per day, my lord. That amount we are seeking only. We are not seeking the regulation, but the tribunal held that the same work, but the regulation, those are waiting for the regulation. The same nature of work, the present petitioners are discharged. Therefore, the right, the tribunal has passed their order, my lord. That is my contention, my lord.
My lord, one judgment. I'm citing 2010 AR SCW 278. The equal pay, where it can be invoked. How good copy?
Second, we have that. The judgment you have already referred.
Yes.
Earlier, no? 2010.
2010.
So, Gyanalok Mohanty for Central Government Council.
Senior Panel Council for Central.
Account Senior
Panel Council.
Senior Panel Council. And you are
Deepak
Kumar Mahapatra for all the opposite parties now.
Two opposite parties.
There are two opposite parties.
Opposite parties.
Take down item number 17. Hard Mr. Gyanalok Mahapatra, Senior
Mohanty.
Gyanalok Mohanty, Senior Panel Council. Senior Panel Council
for the Central Government.
For the Central
Union of India.
For the Union of India. And Mr. Deepak Kumar Mahapatra for the opposite parties. Hearing closed and or is yes.
Maybe permitted to file because I have also relaxed judgment.
File it. Counsel for the respective parties file the citations which are taken under এটা লেখিও petition or উপর লিখে দিও
যদি ফটোকপি দিতে করি
ঠিক আছে আপন তাদের উপর লিখে দেবে অপোজিট পার্টিজ করে না petition or counsel সেটা আজই দেই স্যার
Item 18.
This comes to the Mike Bakutla.
I will ask to file the results because they have filed a counter affidavit of this volume. And I have prepared the regional affidavit, just I'm filing before this court. They have filed a counter affidavit.
I'm appearing on behalf of Mr. B.P. Tripathi for the OP party number 6.
And there are how many opposite parties?
There are 6 opposite parties in total. 5 has merged with opposite party number 6. That has been stated in the counter, my lord.
So 5 and 6. You are for 5 and
yes,
5.
On behalf of Mr.
And for the state, this 1, 2, 3, and 4, they are for the.
They have filed the counter, and I have filed the rejoinder for that.
Minister, you have Minister receive question.
1 to 4.
Now, Ponaji service. The land council for this petition on 5 to present the affidavit. I the report.
The state.
You have taken on that form. Copy of the same has been served on the land and council for the state who is appearing for opposite party number 1 to 4. And also on the land and council who is appearing for opposite party number 5 and 6.
Right.
So you want to go through it?
Yes.
You can take up this matter.
The counter of the opposite party 5 and 6 is saying today.
I'll serve a copy.
It is submitted by the land and council for the state, that is opposite parties number 1, 2, that he is yet to receive the counter affidavit filed by opposite parties number 5 and 6. The land council appearing for opposite party number 5 and 6 submitted that during course of the day will hand over the counter affidavit to the land council for the state. Put up this matter.
Last week of this month.
36 तारीख.
Oh, 36.
Second. This matter will be commencing from 27th August 2020. Yes.
Item 19.
19 on behalf of Mr. Mahanti, my Lord Senior, is not well. 1 week after.
We for the other side.
My Lord.
Mr. S.K. I am appearing from opposite party 2 to 5, my lord.
2 to 5.
5.
There are how many opposite parties?
What for OP1 government?
5. This much of 5. The submission was made by the Land Council for the appellant that Mr. Mahanti is not well and the matter may be taken up on some other day. The Land Council for the state, Mr. Mishra, is also the Land Council for the opposition correspondence numbers 2 to 5. Mr. S.K. has no objection to the same matter in the 27th of August 2020. Yes.
Item 20.
20 also, Mr. also was, like, a mention is made on behalf of Mr. Jan Kumar of the senior advocate for agenda. Land Council for the state has no objection to this put of this matter. Give it 8 seconds of time.
Item 21.
May I please? The rehabilitation assistance scheme, my lord. The petitioner applied for the after the death of his father, my lord, expired is on 6th May 2010, my lord. They have not decision was taken on 8/6/2016, and they have been communicated more than 5 years. They have accommodated since rejected. And in this case, my lord, one thing, my lord, the Ministry of Science and Technology, Department of Science and Technology, Office Memorandum Number dated, my lord, 1/4/2013, instruction, my lord, 5% quota in the total vacancy of the year, my lord. In the prior to that, my lord, the father of the petitioner was died in 2010, my lord.
Have you prepared a chart that when your father died, when you made the application, all these things?
Pardon, my lord. In this case, I have not received copy, my lord.
Yes, already given, my lord.
But I have not copy, my lord.
As per the direction, my lord, already filed, my lord.
The order was passed on 5/8/2024.
Yes, my lord.
For a copy, and he said that in your office the copy has been served. So please verify it, and he will prepare the date chart so that okay. So can it come during course of this week or next week?
Next week, your lord.
Right. Please verify whether the copy has been served. The Learning Council for the petitioner submitted that as per order dated 5/8/2024, copy has already been served in the office of the central government. And the Learning Council, Mr. Padi, takes some time to verify the same. During course of argument, the petitioner, Mr. Mahanti, submitted that the matter may be taken up next week in order to prepare a date chart for this matter next week. Yes.
Item 22.
Well, item 22, on behalf of Mr. Mahanti, I pray for an adjournment, madam. Let it come.
I am appearing for the opposition.
What is the matter? What is your prayer?
And on behalf of Mr. Mahanti, I pray for an adjournment, madam.
You are praying to God of the
6
on the
priority.
tribunal annexure 4 and Krishna. Okay, some land has been acquired and you have to get the employment assistance. So in lieu of that acquisition of land, that has been turned down, and ultimately the tribunal dismissed your action against that. You want it on? Okay. Land counsel for the petitioner, 6 for an adjournment till first week of September 2024. Mr. Gamlo Mahathi, then senior panel counsel, Union of India, for Union of India is present. Place this matter in the week commencing from 2nd September 2020. Please.
Item 23.
23. My lord, as undertaken, I am filing the date chart, my lord. The composite date chart with a copy to my learned senior. Your Lordship, in this matter, learned senior advocate Mr. S.P. Mishra will argue this matter. Today is preoccupied.
Tomorrow.
Let it be on 2nd September. Week commencing
There is a very short point is involved. Well, Supreme Court judgment is covered. After sale certificate, under section 13(8) of the Surface Act, he has no power. There cannot be redemption of the property. Already the third party interest has been accrued, the OP number 3. After registration, sale certificate, everything. Before the amendment of 13(8), it was until the right is there for redemption till the sale. But after that amendment, it is until the auction. So it is auction is over, sale is over. So every time there is no meaning in deferring the matter. However, since my friend is saying so,
there is a distinction. The amendment, amendment. I am not arguing because
all right. The
week commencing 2nd September.
It is submitted on behalf of the petitioner that Mr. S.P. Mishra and senior advocate is on behalf of the petitioner, and a date chart is filed on behalf of the petitioner, which is taken on record.
With a copy to the opposite party.
The same has been handed over to the land counsel for the opposite parties. On consensus of all the parties, put up this matter in the week commencing from 2nd September 2020.
By one legal matter, I think on this score, civil court is not barred.
No, my lord. Civil court is barred because we are challenging the surface action.
No. After that Indian Bank case.
No, even if, my lord, in that
interim order could be there, both the forum can go in parallel, but it is not barred. So for other matters,
my lord, here the difference is they have also approached the civil court, but they have proceeded. They have proceeded.
They have now challenged
the sale notice.
Which is challenged before the Supreme Court.
This honorable.
DRT order.
DRT order.
That is
appellate order.
Appellate order.
Appellate order is
that is annexure 21.
Annexure 21.
Lordship, may record my presence with my learned friend so that last time the Lordship recorded that.
So the senior advocate is present for opposite party number
1 and 2. 1 and 2.
For opposite party number.
With Mr.
Last one, last order of the so also Mr. B.N. Ujjata, let him be for opposite party. Yes.
Item 24.
May I please, your lordship? My lord, in this case, the petitioner is a class 3 employee of subordinate judiciary, my lord. He was proceeded criminally as well as departmentally for misappropriation of money, my lord. Then he was granted bail subject to deposit of the misappropriated amount. Thereafter, he deposited the same. But the departmental proceeding continued and ended in dismissal of service minor. In the present writ, praise for some error which accrued before his period of suspension or before the institution of departmental proceeding. Now, the appeal against the disciplinary proceeding was dismissed, and against that also he preferred a writ petition which is pending before this honorable court in another writ petition. In the reply to the rejoinder at page 4, the opposite party replied to the rejoinder, my lord. Page 4, para 8. The appeal against DP is disposed of, and against that order of WPC is pending before this honorable court. It is further humbly submitted that if any financial benefits is granted to the petitioner during pendency of the aforesaid writ petition, then it would be difficult to carry out the orders passed in the present writ petition. So this is my writ petition. I have challenged the dismissal order. So there is no impediment or there is no problem for the opposite party disburse the arrears accrued before to the institution of the disciplinary proceeding, when I have already deposited the misappropriated amount.
No, where is that that you have deposited the entire thing, or it still remains to be paid?
No, my lord, I have paid the entire amount. That is, my lord, kindly have a glance over page 3 of that reply to the rejoinder.
The counsel, where is your averment to that effect in your writ petition, and what is the counter affidavit?
Yes, my lord.
You have deposited the petition amount.
My lord, in my writ petition, the annexer 3 at running page 23 is the copy of the challan of deposit.
Okay, and what is the counter affidavit they have stated?
No, my lord, in reply to the rejoinder, the state has also admitted the same. Page 3, para 6 of the reply to the rejoinder. Reply to the rejoinder, page 3, paragraph 6. The petition on bail in that case after depositing all alleged dues. So the fact remains.
Is there any arrear outstanding prior to the initiation of the disciplinary proceeding? Is there any arrear at all?
My lord, the petitioners to my lord's notice a judicial order. My lord, kindly see the last order, please.
No, that is what with respect to that one.
Because that is that he should have first brought
no other financial benefit.
22-1-24. My lord, kindly see that. 22-1-24 of my lord's order.
22-1-24.
On the prayer of so and so, list this matter on so and so, WPC be delinked from the present rate. That is the order. 22-1 तो सेया ही लिखा है. On the prayer of the learned counsel for the petitioner, list this matter on 22/2024, stock WPC number 2617 of 2022 be delinked from the present rate petition. That was perhaps filed for that challenging the dismissal order in which that appeal was confirmed. So that order.
My apology, my lord, because my order sheet reflects otherwise, as if actually it reflects as if my lord's directed no. First, this case has to be decided first. 2617 of 22.
No, there is nothing that like that in that order.
I'm sorry,
Mr. Counsel, is there any order that be decided first And then, is there any order passed?
No, my lord, no, my lord. There is no bearing of this writ petition with that writ petition.
Okay. So, no, just we want to know, Mr. Misra, his entire claim is that area remaining prior to the initiation of it. So, question is that, first of all, is there any area at all? Number two,
Yes.
whether there is any bar or any kind of
Yes.
legal hurdles for this
Consequence of dismissal.
That is it.
Yes,
That's
my
two
lord.
things.
Because I was getting ready on the other file.
No. That has not come today, and that has been delayed. So
No, we have that file with us.
uh,
It's of course it's not in the cause list.
huh,
Any day, my lord, this week, my lord, may take up. I will have. I'll be
next
ready.
week.
Also, I'll be ready.
Okay, then it can be taken up on then Wednesday.
My lord.
So land council, it will be taken up on Wednesday.
Limited matter.
Huh?
Limited matter.
Limited matter. Two things just verify.
My lord.
My lord, in next week, it would be better because I have to go.
Okay. The land council for the state seeks some time to wait as to whether there is any area payment of leave salary or dues in favor of the petitioner, and whether prior to the initiation of the disciplinary proceeding against the petitioners, and whether there is any legal order for such disbursement. This matter.
The details, pardon, my lord. The details of the area is mentioned in prayer portion of my writ petition, my lord.
Prayer portion में detail को लिखते हैं.
वो रीट रे आज्ञा prayer portion रे clear detail अछि मो माने को एरिया टा के माने मते केबे accrued होला केबे कोन
कोठी अछि.
Read petition रो prayer रे आज्ञा page 8.
Page 8. Yes, read kindly. We'll see.
The area payment of leave salary and area dues accrual of periodical increments which have fallen due to the petitioner with fixation of pay in revised scale as per the report of the Honorable City Commission before suspension or proceeding period communicated by letter number such and such dated such and such by the learned register civil judge civil court judge Jatpur.
Amount of calculation each in that time.
What is the calculation?
You said that Ajif, we thought that there is some calculation figure has been mentioned in.
Calculation part is not available with me, my.
Yes, it is to be taken up next week as paid for by the land council for the petitioner. Yes.
Obliged, man.
Item 25.
Please, my lord. My lord, here the prayer for the petitioner for a direction given an appointment under the compassionate grounds. My lord, the late father of the petitioner was an employee under the opposite party number 1, and he was also died during his service in the Corona period. Yes, my lord, only because this matter was also heard by the coordinate bench, and the coordinate bench also given a direction that instead of passing any order, you take an instruction from the opposite party that the appointment under the compassionate ground should be given to her or not. That is, and also that apart also, the honorable division bench also directed us that you to give us whether the compassionate appointment scheme is there or not. Page 114, we have given, yes, the compassionate appointment rehabilitation assistance scheme is available. Similarly, also 6 persons has already been given appointment. That is page 91. So only by changing of circle, a direction may issue to consider for giving an appointment by the opposite party number 1. It can be disposed. Let them take a decision.
No, order re kono kotha reflect.
No, not reflected. Only
kothabarta se court re hela don't unless
the order. That was a verbal direction given to.
Unless there is a The judicial cannot say what happened
Sir.
during the
But
proceeding.
only honorable division may.
Was in the mind of the honorable judges who was first taking of this matter.
Let my learned,
Like that. There is nothing on the order.
my learned friend will say whether there was an instruction or not. Sir.
You can argue the matter.
Yes. My late father of the petitioner was also appointed as my lord the grade 2, that is chargeman grade 2. Before that NALCO, and also during that he was expired on 15/4/2021 during his service. That actually due to corona. And the present petitioner also applied for given an appointment under compassionate ground. My lord, the compassionate appointment policy is there with available with the opposite party, that is page 114, and basing on that policy also they have given appointment to the 6th.
114.
Sir, 114, 114. 30 definition. 114. Definition 30. Scheme means NALCO Employee Family Financial Assistance Rehabilitation Scheme. The company shall mean the national so. The employee shall mean an employee appointed in regular scale of pay in whole time permanent employment, including the probationer, and shall include a functional director who is also whole time bona fide employee of the company. And the rehabilitation, these employees can be given rehabilitation assistance scheme, benefit of rehabilitation assistance scheme. And basing on that, sir, page 91, sir. Page 91, 6%, 7%. 7% has
eligibility.
Yes, sir.
Eligibility in page number 116.
Sir.
The benefits under the scheme will be admissible in case of death and so on. So,
sir.
The benefits shall be allowed in case of death due to accident arising out of or in course of employment if the defendants of the deceased employee do not
opted for employment in the NALCO. Applicability in the past cases, the benefit will be admissible in past cases of the death, permanent total disablement, only if the same has taken place on or after 16/11/1995 and the nominees is willing to deposit the amount.
So as per this particular scheme, which you say was prevailing also when you made the application.
Yes, I made the application and also basing on
that counter that whether you are entitled to get the compassionate appointment or not.
This is, in fact, my humble submission is this is not the scheme of compassionate appointment.
Yes.
We have filed the compassionate appointment scheme under the counter affidavit. This they filed subsequently in an additional affidavit, and we replied also that this is not the scheme of compassionate appointment.
It found that is the full.
It a NEFAR scheme gote, it olga. It existing employees. Here in this case, the petitioner's father was.
Oh, it is NALCO employees.
Family financial assistance.
Assistant rehabilitation scheme.
This is
right so on. What is your scheme, the correct scheme according to you? You have annexed it in the counter.
That is at page 56.
Page 56. Let us see that. Compassionate ground. That still subsists.
This is
okay.
So and under this, if you also may see page 56, subclause 1, what is the criteria? The employment on compassionate ground will be considered only on accidental death cases, which comes under the category of arising out of and in course of employment as per the provision of Workmen's Compensation Act. In this case, the petitioner's father was retrenched from service in 2011. After 2011, he was never the employee of NALCO, and he challenged that before the tribunal. And in the meantime, he died. And later on, the daughter of the employee, that is a petitioner number 2, she filed an affidavit also. She withdrew that case. So that termination was set aside. And this was so. This condition clearly stipulates a condition. There is a condition that he should be in employment, and during course of his employment, he should have died. And your lordship, there is also one more aspect. If your lordship may see the prayer in the petition, that is at page 7, the tribunal judgment has not been challenged. They filed an amendment application, but that amendment application they are not pressing now.
7.
Page 7, if lordship may see the prayer. In fact, they took a liberty of this court that they took time on 26 to 2024
Oh,
for
we
seeking
simply
amendment.
to resist employees' family. Awesome. Sympathetic.
After this, they have filed an amendment petition. Subsequently, in 2024, the petition was filed in 2021. They filed an amendment application in 2024. Now that amendment application also they are not pressing.
No, we don't praise the amendment petition. Now, last occasion also we have also stated before this honorable court. No, we have not pressed for the amendment. My lord, so far, my lord, my learned friend is saying regarding the termination. My lord, the page 27. Page 27, the termination order stand passed. In the fact and circumstances of the present, page 29, sir, last order. In the fact and circumstances of the present case, when the ex-employee has been discharged from the duty by the order dated 16/2/2011, Annex A by 1, this tribunal find that no admitted by the respondent organization in refusing to give compassionate appointment in favor of the applicant number 2, which also the
କଣ ପଢୁଛନ୍ତି କଣ ମାନେ
ଆପଣ against ରେ ପଢି ଯାଉଛନ୍ତି।
ଜୋରରେ କହିବା ପୂର୍ବରୁ ଥରେ ତ କମ ସେ କମ ସେ ଅର୍ଡର ଟାକୁ ପଢିବାର ଥିଲା ନା ଯେତେବେଳେ ଜୋରରେ କହୁଛନ୍ତି
ସରି ସାର୍
ସେ ଯୋଉଟା ପଢୁଛନ୍ତି ସେଟାକୁ ଟିକେ ଆପ୍ଲିକେସନ ଅଫ ମାଇଣ୍ଡ ଦରକାର ଖାଲି ଜୋରରେ କହିଦେଲେ ହବନି ଭଏସ ରେଜ କରିଥିଲେ କିଛି ସବମିଶନ ରେ ଜୋର ଥିବା ଦରକାର
ସାର୍ ସରି ସାର୍
କଣ
page sir page 6 page 16
Page 16.
on page 16 that is in page 19 that is there in consideration of the above I dispose of this OA at the stage of admission by advising the applicant to apply against the advertisement of suitable vacancy
କୋଉଆଡେ କଣଟା ପଢୁଛନ୍ତି
କୋଉଟା ପଢୁଛନ୍ତି କଣ
କୋଉ 16 which 16
page 16 sir
running page 16
yes running page
annexure କେତେ
annexure 6
16 ରେ ତ 6 ନାହିଁ
Annexure 5.
5 sir
annexure 5 is 16
Annexure 5.
yes annexure 5
ସେଥିରେ କଣ ଲେଖା ହେଇଛି as per the discussion
with the director executive director another senior officer of NALCO Bhubaneswar on 8th September 20 of Bhubaneswar the case of Sri Mohan Behera has been discussed and the authorities has considered for reinstatement of the Sri Mohan Behera. Mohan Behera is the deceased and he has already been reinstated.
Kahin? Kebe? Next.
You'll also see the next page. That is
it.
After this, we have offered on 8/12/2011.
Yes.
We offered, but he did not accept this and never joined.
Oh.
That is our case.
On your joining, sir, on your joining, you will be governed by the rules and regulations of the company. Sir?
What is your joining report?
That is, they have admitted, Annexure 6. Page, sir, 17. On your joining, you will be governed by...
No. On your joining is a condition, sir.
Sir.
When did you join?
Did you join that?
Yes.
He never joined.
Yes, he has joined.
Kebe?
You have joined, then must be a joining letter.
Can it be taken up, sir, next week? Just.
ଯେତେବେଳେ ଇଏ କହୁଛନ୍ତି ଡେଟ୍ ଚାର୍ଟ ଟିକେ କରିବେ ଟିକେ
ଆଜ୍ଞା
the learned counsel for the petitioner 6 for an adjournment with this matter on the bench 2020.
You'll also may refer the submission that his amendment application.
Yes.
Because that is what his submission is.
You are not pressing.
Not pressing the amendment.
Number 8575 of 2020. There is an application for amendment filed by the petitioner. Learned counsel for the petitioner does not want to praise this application. This both of are not pressed. Yes.
Oh, bless.
2017 ରେ ଆପଣ ଗୋଟେ ଚିଠି ଦଉଛନ୍ତି ଯେ due to some unavoidable situation I am unable to join.
Yes.
In 2017. This offer was in 2011.
Yes. He's never joined.
I may be pardoned, my lord. Item number 53 of this weekly list, my lord. Second half weekly list. Item number 53. The criminal appeal, my lord. The appellant has been convicted under section 302 for life, my lord. He has spent 13 years in jail. I pray the matter could be taken up for hearing.
For hearing.
My.
Okay, we'll take up. We are taking off the orders matter first, then we
I pay for 2 more.
see that how many orders matters are there. See that.
List item number 6.
Item number 6, may I please, Your Lordship. Last occasion, instruction was called for my application under section 389 for the appellant who has been in custody since 1/3/2008. Only praying for bail.
What is the allegation against student?
Lordship, 362F and 302. Minor girl, 8 years old.
Book reading. Book reading.
Aguru military reject hitla.
My lord, he has never been released.
Oh, reject kotha pocho.
Reject him.
Granting him interim bail and directing the office to prepare the paperwork. Religion custody for 16 years. IN number 1730 of 2024. Decision application for bail. As per the order dated 29/7/2024, the Gun and Counsel for the state has produced the custody certificate issued by Superintendent District Jail Balashore bracket welfare service, which is dated 2/8/2024, which indicates that total sentence undergone by the petitioner is 16 years, 5 months, 3 days. Run counsel for the petitioner submitted that the paperwork is not yet ready and therefore there is no chance of early hearing of the appeal in the near future and therefore their application may be favorably considered. Run counsel for the state on the other hand opposed the prayer for bail and submitted that it's a case of rape and murder of a minor girl who was less than 12 years age at the time of occurrence. Considering the available material on record and nature and gravity of the petition, were not inclining to release the petitioner on bail on mailing, taking into account the period of between judicial custody and since paperwork has not been prepared, we are in the petitioner on interim bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activity, shall not try to come in contact with the family members of the deceased, and the office is directed to prepare the paperwork in the meantime. matter to be listed on such and such date, you will file the surrender certificate. Yes.
My lord, also I have submitted the original copies of the deposition state.
All right. Let the office prepare the paper.
Obligation.
Item number 7.
May I please, Your Lordship, permitted to appear through virtual mode, Your Lordship. On the last occasion, Your Lordship directed for CA and antecedent and conduct of the present appellant.
Custody certificate I brought it, but the misutilization that 11 years 7 months.
He surrendered. He was released on interim bail when last time?
Your Lordship, on 1/5/2019 for 30 days.
What is allegation against you? What you have done?
The present petitioner, along with others, attacked the deceased, Kamal Lochan Dale, Your Lordship. There are 4 eyewitnesses.
Come to paragraph number 2.
Yes, Your Lordship.
Tata Indigo car stopped the car in front of the college. Got down from the set car, the armed with radio. They suddenly attacked Kamal Lochan Dale. Staff those were the It's a case of double murder.
Yes, Your Lordship. In the meantime, Your Lordship, Proboscis alias Kisu has been released on interim bail by the court for a period of 3 months, Your Lordship.
The connected appeal.
Yes.
Yeah,
That is 2/10 of 2017.
110. Acha.
Yes, Your Lordship.
Also,
Promises could you there?
Kisu alias Kisan.
Yes. And promises, Mr. was allowed only.
Interim bail. So, Sijao, Piniman Sijai. Are these current counsel for the petition and this case in pursuance of the order dated dated 24/7. The London Council for the State has produced the custody certificate, which indicates from Superintendent Swanson 11 years, 7 months, 8 days taken on record. Council submits that similarly situated co-accused, namely Kishu alias Kisan Chandra Mishra alias Probasis Mishra, has been directed to be released on interim bail for a period of 3 months by this court in connected criminal appeal number so and so here by the order dated in this case number so and so, and taking into account the ratio laid down in the case of Letty versus one. Therefore, the petitioner may be granted interim bail. Grand counsel for the state prayer for this, considering the submission, so and so 3 months will be granted. See the condition of same condition. Date fix up for the sorry. All the mistakes that you are for stay of realization of fine allow for the
Number 8.
Includes my lord. Initially, the actual was in Bhavanipur. They have to have transport to Rampur jail. From there, very about nothing. Rampur jail has sent postal certificate of 7 years. ତାପରେ ସେ କୋଉ ଜେଲ ଅଛି ଜାଣିଲେ
Instruction Khorial, my lord.
Khorial.
ये जो पिटिशन टा पड़ीथिला ସେତେବେଳେ ସେ ଥିଲା ସବ୍ ଜେଲ ର ଏମ୍ ରାମପୁର ତାପରେ ବର୍ତ୍ତମାନ ଆଉ କୋଉଠି ଅଛି ଜଣା ପଡୁନି ଫାର୍ମ ଟା ବି ଅଛି ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସବ୍ ଜେଲ ଏମ୍ ରାମପୁର ଦେଖନ୍ତୁ ସେ କହୁଛନ୍ତି ଖରିଆରେ ଅଛି ବୋଲି ଆପଣ ବର୍ତ୍ତମାନ କେବେଠୁ କେବେ ଯାଇ ପାଇଗଲେଣି ପ୍ରଥମେ ସେ କୋଉଠି ଥିଲା
ପ୍ରଥମେ ଭବାନୀପାଟଣା ହେଲେ କି
ନାଇଁ ଏକାଥରେ ଦେବେ ଭବାନୀପାଟଣା ପାଇଯାଇଛନ୍ତି
ଭବାନୀପାଟଣାରୁ ତାପରେ ଟ୍ରାନ୍ସଫର ଟୁ ରାମପୁର ଜେଲ
ଭବାନୀପାଟଣା ତାପରେ ଏମ୍ ରାମପୁର କଣ ମଦନପୁର एम रामपुर
up to 16/11/2020 I got
16/11/2020 अच्छा भवानीपाटना स्टार्ट ହେଇଛି କେବେ
2013 टू
13/9/2013 अच्छा ସେଇଠୁ ଜାଣ ଦିଟା ଯାକ ଡେଲ ହେଲେ 16/11/2020 ପର୍ଯ୍ୟନ୍ତ କଭର ହେଇଯାଉଛି ତାପରେ your instruction is that he has been transferred to କୋଡି ଗଲା shifted to Khoriar collect the IA number so application for bail land council for the state submitted that he has received custody certificate from superintendent of sub jail na kon sub jail first hauchi भवानीपाटना तो भवानीपाटना
भवानीपाटना is sub jail.
So Bhavanipatna jail and
Sub
jail which covers from the period from 13/9/2013 due to 16/11/2020 but thereafter it could not be ascertained where in which jail the petitioner has been lodged. The Land Council for the appellant submits that the petitioner is now lodged in Khoriar jail. Let the Land Council for the state obtain instruction from Khoriar jail authorities regarding the custody period and the matter be placed next week. Yes.
Number 9.
Mr. Manoj.
Mr. Pandey is just on his way, madam. It's one pass over.
Number 10.
That matter, my lord, there is an allegation against me that yes, 4 cases are pending. During also custody, there are allegations and there are cases. That matter, my lord.
Discussion, my lord. Though the first instance I have stated that there is one case, no case, my lord, against both the petitioner, my lord. Subsequently, this allowed directly take instruction. I have obtained the instruction of 4 cases, my lord. Since my lord 60 TNS, my lord, not available, this petition not named in the FIR. For that reason, High Court of Orissa is unable, my lord. Subsequently verified.
Okay, pass on.
But council, my lord, senior council applying for the informant filed an affidavit. Enclose the 3 cases which are pending against 4 cases which is pending against me, giving the particulars. I also rely upon that. But my humble submission, my lords, I will refer to those and I will submit my submission.
You are arguing in which case?
In item number, Santosh Kumar Maharana 649 of 2019. Because my lords, kindly glance to all total 5 accused persons.
In this 649, there is only one appellant.
Minutes? One. Each appeal minor, there one.
Yes,
So for Samsundar Pusti, who is the main kingpin minors, at whose instance all this has happened.
Okay.
All the cases charge sheet submitted.
In pursuance of the order dated 29 CRLA number 649 of 2019. In pursuance of the order dated 29/7/2014, the Learning Council for the state has produced inspection from IAC Khalipur Police Station. Which is 6/8/2024, which shows that apart from this case, there are
other 4 cases.
Apart from the case in hand, there are 4 criminal antecedents.
In connecting this particular issue, my lords. Connecting this particular issue.
Not just
No, my lord. One case, my lord. Last case, my lord.
Mahapatra.
Last case, all right.
It's these cases are, one is of 2013.
Minutes.
The other is of 2016 on different dates.
Yes.
One is 2022.
Yes, ma'am.
The
third one and
committed that.
Just a minute. Please allow me. Please allow me. Sir. So far as the first case is comes 2013, but my instruction is that I don't have a detailed instruction. My instruction that they say that this is prior to the incident. But so far as this incident is concerned, other 2 repetitions are the bail petitions and the proceedings were there. Their cases are there. While we were in custody, we were threatening the witnesses. This is the. So far the 4th is concerned, my lord. That case is when I was in follow. Then
if you want to say anything by way of an comprehensive affidavit, you may say so. But now we find that there are 4 cases instituted against you. Apart from this case, there are 4 cases. One was obviously prior to the commission of offense, this case.
Yes.
And the other 3 while you were in.
No, two while we were in custody.
Yes.
Along with others, and third one was while we were in parole.
Yes.
4th one, parole. And I got bail there. There is no, so far as all the cases are concerned, I got the bail. But they may submit one thing, matters. In particular contest mailers, there are 5 mailers.
Yes. Four cases were instituted against the petition. Yes.
Well, the case is like this, my lords. P. Samsundar Pusti is the main kingpin, my lords.
Yes.
P. Samsundar Pusti is the main kingpin, my lords. He runs a cashew factory. He engaged some minor child laborer. The deceased my lords was a journalist and he reported against them. That is why Samsundar Pusti first, with the help of others, first led that particular commission of offense. Samsundar Pusti got bail.
What is the name of the deceased?
Well, Samsundar Pusti, my lords.
Samsundar Pusti.
Samsundar Pusti Samsundar Pusti is not the deceased. This is
asking you what is the name of the deceased.
This is my
Ganthi alias Tarun Acharya.
Tarun Kumar Acharya.
And what is the date of occurrence?
Date of occurrence is
27/5/14.
27/5/2014.
It was registered just.
All right. So eyewitnesses are there.
Yes,
Sorry.
Lordship, in the FIR last occasion, I have
No, no,
submitted FIR was
Yeah, ପଚାରୁଥିବେ କଣ ତାପରେ argue କରିବେ।
circumstantial evidence, my lords.
Whether there is any eyewitnesses.
Circumstantial evidence.
So no eyewitness.
But if the case will be no eyewitnesses, if the case will be taken as a whole, my lords, that shows that some semblance of evidence that there is an eyewitness
as per FIR.
as per the affair.
ଓ ଏଫଆଇଆର ରେ କଣ କହିଛନ୍ତି ଯେତେବେଳେ ଟ୍ରାଏଲ ରେ ଯୋଉ ସାକ୍ଷୀ ହେଲେ କୌଣସି
No, that is purely circumstantial.
that's
Purely circumstantial.
what are those circumstances?
The circumstances is that, my lords, that first is that Samsundar Pusti foisted the plan, arranged these
Whether
persons.
it has been discussed that what are these total, these are the circumstances.
Yes, madam.
In the judgment, whether it has been chalked out.
Yes.
That these are the circumstances.
What is
the page number?
Judgment.
Yes, in the judgment, whether it has been jotted down that 1, 2, 3, 4, this extrajudicial confession, this, that, like these are the circumstances. Or it has not been done.
No, it's not been done in such a systematic manner.
Tell us that what are the circumstances.
So the thing is that manners, three things. First, Samsundar made arrangements and organized these people, still discussed, and thereafter a commission of offense.
Samsundar ki?
That's the main the appellant number 1. The appellant in case of CRLA 30503 of 2019.
Samsundar तो तारा criminal appeal तो नहीं है जी?
आज नहीं से बेल पाई सर चंपो
हो हेला कौन तो
से बेल पाई सर चंपो
कौन हेला
Samsundar, the case is like this. Samsundar has a cashew factory. Some child labor were working there. Okay. The deceased is a journalist. He made some allegations of paper, reported in paper about that engagement of this child laborer. That is what Samsundar, with the help of others, organize this crime. Three contingencies, matters. One is that they have come and sat in a hotel, discussed, thereafter the offense has been committed. But one thing, matters, I'm going a bit beyond the scope. One thing is there. What happened? Well, so far FIR story is concerned, the brother of the deceased, who was following him, coming behind, found, yes, in categorical term he said, found 3 persons throwing a body to the side of the road matters. He found it. First, may I place this portion of the affair that I think will weigh in the mind of judicial mind of the court on matters.
You see, we are not hearing the matter on merit. We are on a bail. Whether you
only to say matters, apprise matters about the prima facie contingencies about the acquittal matter.
We cannot even give any finding that.
Not necessary. I also may I submit one thing only to say things how things have got a different dimension.
Okay. So FIR रे कोइला फोपाड़ी दी गले बोली कोन
फोपाड़ी दी गले बोली कहि दी तलते हम किछ कहबार नथला फोपाड़ी दी करी गले किए फोपाड़ी दी करी गले से देखु छी एक्स वगैरह and he is submitting that ए लोक माने फोपाड़ी दी करी गले
then what up
से फोपाड़ी दी की जो माने गले समान ना FIR ला जाला परवर्ती परिस्थिति there was an investigation na neither means these people were cited as evidence nor they were taken as accused. Nowhere the person concerned, the informant who has stated the evidence, he admitted that he has stated so. The IO said that in my presence he has stated the names. And the thing is that thereafter, anyway, there is a conviction. So far conviction is concerned, 5 appeals were preferred. These people were kept outside beyond the scope of beyond the purview of the investigation, and we have been brought into conviction. Samsundar Pusti came. Samsundar, the allegation, like my wife told me, the allegation is that Samsundar, it is stepping out of the contingencies which is arose in that cashew factory, and this is the reason. Samsundar got the bell. Then S.K.Sahoo, he got the ready. S.K.Sahoo got the bell before the honorable court granted the bell. Then Shivram Naik, who told the he became a witness, some Prusti, that yes, we are going to do this. Shivram Naik also have been released on bail. Now we two, Santosh Maharana and N. Ramesh.
So what is the allegation against you?
Allegation against me is that I along with them, I committed the crime.
Evidence कौन आसिला आपनको ना?
Oh, against evidence ବୋଲି ସେମାନେ ତ specific evidence ନାହିଁ, ମୋର against ସେଇ circumstantial evidence ନଉଛନ୍ତି. Circumstantial evidence ନେଇକି କହୁଛନ୍ତି, ମାତ୍ର particular କୌଣସି ଜାଗାରେ evidence ନାହିଁ ଯେ ମୁଁ ଏଇଆ କଲି କି ତା କଲି କି ଏଇ attribute କଲି, excepting am I attending in the meeting in a hotel at Bargol. ସେଟା କହୁଛନ୍ତି Barkul ନା? Barkul.
There was a meeting in a hotel.
Hotel.
So some witnesses have stated about that.
Some witnesses have stated, but there is a CCTV. That is PW University, that is PW 36. PW 26 has stated on the occasion of Savitri Amavasya, he saw that Sam Sundar Pushti along with those actors, they are at Barkul Hotel. And the hotel manager was examined. There was also CCTV was there. CCTV was functioning. There is no CCTV was also not seen.
Consulted.
And another person was also.
तो ସେମାନେ ଏକାଠି ଥିଲେ ସିନା discussion କଣ ହଉଥିଲା?
Discussions is there only
together. Okay.
Yes, my lord.
Together they were proposing to commit that crime.
So there is no material what they were discussing amongst them.
No,
my
Are you sure?
Lord. We don't 26, my lord.
I heard Suresh Sahu saying today the work would be finished, but it requires more money. Persons just a day prior to Shivaratri Amasya, I saw them in Kosturi Hotel. The hotel situates on the way of Pranthanivas at Barpur. I saw 5 persons coming out from the Kosturi Hotel and I heard Suresh Sahu. So Suresh Sahu ki
one of the
released on there. And besides me, so are there. So that is all. That in that hotel, this thing happened.
Yes, ma'am.
Okay. What else is there?
Another PW 10. That is an extrajudicial confession made by PW 10 made by Sudhanshu Sekhar Sabha.
PW 10. PW 10.
See here that while he was going to the Sambhaji Barampur, Sigoram Naik has stated that he told me that he and Samsundar Pushti connived together and hired Gundas from Barampur and finished Tarun Acharya. I have been examined. And he has stated
Subram Naik told me that
while was in the cashew factory, some 2 to 3% against three persons came in 2 motorcycles to the cashew factory. They talked with P. Samsundar Pushti. I saw Samsundar Pushti asking them to received 50,000 rupees and told them that he will consider things later. Out of these 3 persons, 2 persons are present in the dock. He pointed out Santosh Maharana and but what was discussed that was not
And told
and
them,
he not 10 to 12 days. He is also one relative of the deceased, cousin. 10 to 12 days after my you know the from the news matter regarding the date.
so that means P. Shamsundar Reddy handed over rupees 50,000 to this man, this Santosh Mar.
Santosh Maharana and N. Ramesh Reddy.
Purpose that
And Santosh Maharana and so on.
These two, with the two.
And Ramesh Reddy.
Handed over to Santosh and Ramesh. Okay. Both are these petitioners.
Yes, madam.
Santosh and Ramesh.
Another thing, so far as my appellant is concerned, in Ramesh Reddy, they are giving a recovery of 2 motorcycles. That is belongs to other accused person, which has also recovered from the house of other accused persons, not from the house of the
Santosh or Reddy?
that is
In
Ramesh Reddy.
In Ramesh.
2
motorcycles were recovered at your instance.
But not from the house of the petitioner, that is from the house of other
Co-accused.
persons. And also not belonging to the house, motorcycle also not belonging to the, my N. Ramesh Reddy.
Okay.
And
yes.
And so far as the end, I have brought your lordship's attention. As far as the first instance FIR is concerned, he has also category deposed. These persons are these persons who has named, they are nothing but his cousin brother of the deceased. He categorically stated that these 3 persons were throwing the dead body. And he has also deposed in the evidence, and the IO has also categorically stated PW38 that he deposed like this. My lord, PW38, my lord.
ଯୋଉମାନେ ଡେଡ୍ ବଡି ଥ୍ରୋ କରି ପଳେଇଲେ ସେମାନଙ୍କର ଲାଇବିଲିଟି ମେ ବି 201 ଆସିପାରେ ତେଣୁ ସେମାନଙ୍କୁ ଛାଡିଦେଲା ବୋଲି ଆପଣ ମାନେ ଯୋଉମାନଙ୍କ ନାଁରେ ମ୍ୟାଟେରିଆଲ ଆସୁଥିବ କଣ ସେମାନଙ୍କୁ କରିବା ଜରୁରୀ
ସେମାନେ just before half an hour they are throwing mess. And they might be, they have not even not been examined.
You want to say?
Those 3 things, manners. Somebody has thrown the dead body. Must be considered maybe at that particular place. They are the best person to explain.
Yeah.
Then second, maybe bringing from somebody some other place and throwing it. Then also they are the best person. My humble contention is that had these people been brought into the desk super that for examination or cross-examination, cited as witnesses, or otherwise proceeding have been initiated against them, things would have been different. At least truth could have come.
Yes.
Because they have categorically stated, because they are all related brothers. And earlier, my humble contention, lot of litigations between them leading to criminal proceedings, civil proceedings, these were pending. He categorically stated that he has seen these 3.
There was also civil dispute and criminal dispute between 2 families, those who are named in
the named persons and the deceased family.
Where is the custody certificate of both?
Custody certificate and government documents.
Another thing, when the circumstances matter, the phone call details. Phone call details of the deceased was recorded. When the investigation starts, that to the deceased number, 2 unknown numbers were coming. And to that number, my lord, 1 number is my lord that belonging to Sam Sundar. and Sam Sundar ସହିତ ଏମାନଙ୍କର ରିଲେସନ ବୋଲିକି ସେମାନେ କଣ୍ଟାକ୍ଟ କରୁଥିଲେ ଏଇ ଏଭିଡେନ୍ସ ଗୋଟେ ଆସୁଛି।
What is the custody certificate? Please pass on that. That is not there. In each of these criminal appeals, one appellant is there.
Each one. Santosh Ravi.
What's your problem?
Narayan.
This is 4724. On the period, total period.
Narayan is concerned, my lord. 10 years, 5 months, 9 days, my lord.
10 years, 5 months,
9 days.
Narayan is 10 years.
My lord. So for this other, my lord, the
10 years, 5 months. Okay. And Santosh is Lekhaichi 3000.
That is Santosh, my lord. Santosh. Narayan.
5 Lekhaichi.
Santosh tam de deise.
Nice.
Narayan, my lord, 10 years, 5 months, 9 days.
50 years Lekhaini upon you are
Say not complete 10 years, my lord. I calculated, my lord, not complete 10 years, and that also, my lord, he was a.
Okay. So that apart, you say that Santosh has criminal antecedents.
My lord, so there, my lord, I have a small submission again, my lord. So just to reiterate my humble contention.
Yes.
So far as the 2013 case, my lord, sir, is no connection with this. 2013, my lord. My learned senior has given an affidavit enclosing the documents that is under 341, 294, 323, 324, 120B as 506, 34. That is.
Yes, what do you say?
My lord, here, my lord, 4 circumstances are formulated by the PP, my lord. That has been reflected in page judgment, my lord, paragraph 18, my lord. Paragraph 18, my lord.
And judgment.
That has been, my lord, detailed, my lord.
Paragraph number 18.
Paragraph 18, my lord, of judgment, my lord. A, B, C, D.
Yes, sir.
Under A, visit of deceased to the cashew factory and threatening the accused P, threatened by accused by P. Samsundar Reddy. B, publication news item in the Daily Sambad and telecast in the Konkan News, but the motive is concerned, my lord. In the instance of deceased, my lord. Then hatching of criminal conspiracy by the all accused persons to emulate the deceased. Occurrence and death of the deceased on account of knife injuries, subsequent seizure, etc. in criminal articles. Absconding of the accused Santosh Marana. He has absconded, my lord. Thereafter, my lord, here, my lord, since the brother of the deceased, my lord, an advocate of this court, he has filed on in front of file, my lord, in action against police petition here, my lord, the High Court, my lord. Then the matter handed over to crime branch, my lord. Crime branch during the investigation arrested these persons, but they are absconded, my lord, from Odisha, my lord. The Santosh arrested from outside the state, my lord, Nagpur, my lord. Then, my lord, extrajudicial confession of Lalu, alias Shivram Naik, my lord, that has been clarified, my lord, in paragraph 20, my lord. All the circumstances, my lord, 1, A, B, C, D.
This last circumstance is against Shivram Naik,
my lord,
who has been granted bail.
My lord.
Then we'll come to that absconding.
My lord.
Then about 1 and 2, these are general thing about this motive. That visit of the deceased, these 2 persons are not so this hatching of criminal conspiracy is in sota se ju hotel katha se ju borobor na borobor ju hotel da, except that there is no
that is the also extrajudicial confession.
No, we go focusing. Extrajudicial confession is by accused Shivram Naik. He has been granted bail. And hatching of criminal conspiracy, as has been pointed out, that is the evidence of PW10.
My lord.
So if you come to PW10,
Then my lord, and come to paragraph 32, my lord, hatching of conspiracy, my lord.
30.
Judgment 32.
এটা কি কইছেন্তি যে
Schedule 26
criminal conspiracy
hotel
হ্যাঁ সেটা কি কইছেন্তি PW26
circumstance C.
C, my lord, hatching of conspiracy, my lord. Hatching of conspiracy
26 ରେ ଆମେ ଯଦି evidence ଦେଖିବୁ,
my lord,
he has identified two accused. Just see that. I know accused S.K.Sahoo and Sam Prusti standing in the dock. Correctly identified. I do not know the other accused person standing in the dock. That means he has failed to identify these two.
No, my lord. Whatever, so far that witness concerned, my lord, that he specifically stated two of the accused persons, not my lord. They are the my lord, they made conspiracy with this. For that reason, he has not identified.
By then only
not seen, my lord, these petitions, two petitions are real culprits. They are the author of the crime, my lord. They both of them, my lord, they taken rupees 50,000 from the.
ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ତାଙ୍କ ନାଁରେ କଣ ଆସିଲା କୋର୍ଟରେ, ଆପଣ ସେଇ ଯୋଉ ଇଏ କୁହନ୍ତୁନି, ଷ୍ଟୋରି ଆମକୁ କୁହନ୍ତୁନି, ଏଭିଡେନ୍ସ କଣ ଆସିଛି? ଆପଣ ଯୋଉ କ୍ରିମିନାଲ କନସ୍ପିରେସି ଗୋଟେ ହ୍ୟାଶ୍ଡ ଆଉଟ୍ ହେଲା ବୋଲି ଏଭିଡେନ୍ସ ଆଣିଲେ, your only witness to that circumstance is PW26 or not? PW26 has he stated that these two persons who are before us now, the appellant, are they present at the time of criminal conspiracy?
But the 26 are not stated, my lord.
How that circumstances can be utilized against these two persons?
But in fact, my lord, 26 is concerned, my lord. He has since seen two of them, my lord, not the others, my lord. That is my lord. That is my lord.
ଯଦି ସିଏ ଏ ଦି ଜଣଙ୍କ ନାଁ କିଛି କହିନି, ତାହେଲେ ତାର ଏଭିଡେନ୍ସ ଟା ୟାଙ୍କ ନାଁରେ କେମିତି ୟୁଟିଲାଇଜ କରିବେ ଆପଣ ଯେ ଇଏମାନେ କ୍ରିମିନାଲ କନସ୍ପିରେସିରେ ପାର୍ଟିସିପେସନ କରିଥିଲେ ବୋଲି? ଯଦି କ୍ରିମିନାଲ କନସ୍ପିରେସିରେ ଏମାନଙ୍କର ପାର୍ଟିସିପେସନ ଗଲା, ଆଉ ରହିଲା କଣ ସେ କେସରେ?
CCTV footage, my lord, and then my lord,
ଆପଣ ପା ଦେଖେଇଲେ ଯୋଉ
PW13, my lord, PW13, my lord. So with regards to, my lord, the identification of these two appellants, my lord, PW13, my lord. My lord, paragraph 3. During TI period, I identified the accused Santosh Maharana. This is the TI period report which I signed. This is my signature marked as with time.
ସେ ଆଇଡେଣ୍ଟିଫାଇ କରିଛି ଯେ ତାର ଆଇଡେଣ୍ଟିଫାଇ କଣ ନା ପି ଶ୍ୟାମ ସୁନ୍ଦର ତାକୁ 50,000 ଟଙ୍କା ଦେଉଥିଲା ହେଲା। Out of these 3 persons, 2 persons are present in the dock. ସେ ଆଇଡେଣ୍ଟିଫାଇ କଲା ତ ପି ଶ୍ୟାମ ସୁନ୍ଦର ରେଡି ଦିନେ ତାକୁ 50,000 ଟଙ୍କା ଏ ଦିନକୁ ଦେଇଥିଲା। ସେଟା କେବେ ଦେଇଥିଲା, କଣ ପାଇଁ ଦେଇଥିଲା, କଣ କିଛି ଅଛି ଏଭିଡେନ୍ସ?
That is not there, but
then you link with the crime in question.
When there confession statement recorded, they have stated that he has given the money and lead to the police man gave recovery of the iron knife and also sold some
additional statement of accused before police. So how far that is admissible?
That the material that has been seized, my lord, knife and also the motorcycles, my lord.
It's all right.
But that is connected to the crime, my lord.
ଯୋଉ 27 ର ଏଭିଡେନ୍ସ ଟା କେତିକି ରେଲେଭେଣ୍ଟ ହବ?
Only materials.
So how can you say that ଏଇ ଯୋଉ ସେ ଯୋଉ କନଫେସନ କରିଛି 50,000 ଟଙ୍କା ତାକୁ ଦେଇଛି ବୋଲି
that is not admissible, but in fact, my lord, so with regards to
ଏଇ ଯୋଉ ଲୋକଟା ଯାହା ଦେଖିଛି, if that is taken into account, then ସିଏ କଣ ଦେଖିଲା ଯେ I got the news so in prior to 4-5 ଦିନ ପୂର୍ବରୁ I had been to Kodala. While returning, I went to cashew factory of so-and-so to purchase 1 kilogram of cashew. Accused P. Samsundar Reddy is present in the dock. While I was in the cashew field, again says so-and-so, 2 motorcycle एमाने 3 जण लोक आसिले, तांको विषय कोन थी कथावार्ता हेले, कोन विषय नाही. I saw 50,000 rupees Samsundar asking them to receive 50,000. I told them that he will consider things later. ଏତିକି ହଉଛି କଥା।
ମାନେ
ଯୋଉ ଲୋକ 50,000
2 persons are present in the dock pointed out Santosh Maharana in Ramesh Reddy. They are there, my lord.
से दी जण जाक
Madam.
आसिले तांको
Madam.
कैसियो नोट फील्ड को
Madam.
ए जो जोटी बिकुतला तार फैक्ट्री को सेठी 4-5 दिन पूर्व सीधा 50,000 टका दे एती तो कथा हो
My lord. Then, my lord.
164 has been recorded.
My lord.
Any material?
164. 164.
जति आपण एविडेंस प्लेस कले वर्तमान
My lord.
these are the witnesses who are relevant.
My lord.
So तादियो 3 जण 4 जण पेले गलेनी बेटी सुरेश साहू जाइचंती पेले देन श्याम से जो श्याम सुंदर पुष्टि जहा को कि आपण मास्टर माइंड बाय ये हिसाब रे कोचंदी he has been released on bail in the connected criminal appeals. Sivaram Naik has been released.
And since, my lord, both the petitions, my lord, the entire case recorded and taken into consideration, my lord, they are super. These petitions are author of the crime and super killers, my lord. Unlike the one accused till 8, my lord, his whereabouts not known, my lord. One of the co-accused, my lord.
Yes, sir.
And these petitions are after the occurrence absconded, my lord. Only because the case handed over to crime branch and the crime branch investigates and apprehended them outside the state, my lord. There is every chances of they may be absconded, my lord. And during also Santosh Maharana, while on parole, my lord, he has committed another crime, my lord.
That we have noted down.
My lord.
Charge sheet was submitted showing him as absconder. Santosh.
My lord. Subsequently,
Santosh and both.
My lord.
Narayan and Santosh.
Santosh, another my lord, co-accused, my lord, he has not yet, my lord, apprehended.
Not yet.
My lord.
I was in Ramesh.
In Ramesh
arrested, my lord.
संतोष ताले absconding हिसाब रे चार्ज शीट दिया गला दैट अपार्ट DS4 criminal antecedent ये होची संतोष against
मार then crime branch hand over बोला crime branch जाएगा arrest
बाकी
पुनरु
in Ramesh ता arrest है
knife also seized from Santosh Mehta
knife seized
weapon of offense and he has not completed till it was 10 years, my lord.
Yes, Mr. Misra.
Lord, Lordship can see the evidence of PW30. This is Pradeep Acharya.
Yes.
He was my cousin. I got the news of his death in the month of May 2014. Prior to 4 to 5 days of his death, I had been to Odala. While returning, I went to the cashew factory of Shamsundar Pusti to purchase 1 kilogram of cashew. The accused Pusti is present in the dock. While I was in the cashew factory, 2-3 persons again say 3 persons came to motorcycles in to the cashew factory. They talked with Shamsundar Pusti. I saw Shamsundar Pusti taking them to the receipt 50,000 and told them that he will consider things. Out of these 3 persons, 2 persons are present in the dock. We pointed out to Santosh Maharana and Ramesh Reddy. One of the motorcycle was of Bajaj Avenger of blue color, another was a white color scooter type of Honda made. So this is the during the paragraph 3. During PI period, I identified the Santosh Maharana such and such. Then your lordship can see evidence of PW24.
Yeah, Mr. Just 1 minute. Mr. Rogod.
My lord.
ये जो 4टा ऑफेंस देइछंदी पैरोल रे गला बेले को ऑफेंस
last 94
अच्छा आ जेल भीतर दीटा करछि
my lord
जेल भीतर दीटा जेल इनफैक्ट जेल भीतर तीनटा आइतला दीटा रे मते इन्वॉल्व करके करा हला आ गोटा करे इन्वॉल्व होतला जोटा के आकुटा लई जाई अन्य मान को नेकरी इन्वॉल्व कर
जेल भीतर थ्रेटनिंग विटनेस इन द प्रेजेंट केस my lord
हला जे माने ये जो फलीकोट पीएस केस नंबर 253 ऑफ 2016 टा आउ फलीकोट पीएस केस नंबर 265 ऑफ 2016 एगुडा होची जेल ले थिला
but the interesting part is that you can visualize
Samsundar
Pusti these cases were there and your lordship had directed what made the IO or the police
No,
not to give this.
Now it has
What might be the arrangement? What might be the
You
arrangement?
rightly pointed out, and then now they have come up with
The
that.
Herculean task, my lord, the whole point is that is why the
Yes, Mr. Mishra, please continue that.
Yes.
Yes. Now we have seen the evidence of PW 13 as you pointed out.
Yes.
Any
Yes.
other evidence you want
24,
to?
ma'am.
24.
20.
I know Lulu journalist or such and such. I don't know his good name, such and such. I was in Boston, Calicut at about 8:30 9 a.m. At that time, went to urinate behind the medical building. I saw Lulu journalist was talking over phone with somebody. He was telling
Lulu journalist মানে কি আছে?
This is sorry, Sivaram Naik. Another journalist, my lord.
No, my lord. Lulu alias Sivaram Naik is also a journalist. He is also an accused who has been released on bail.
No, it's all right.
Extrajudicial confession.
All right. Yes, Mr. Mishra.
He was telling the receiver of the call to Girish Granthi, Sambadika at any rate. He was telling over phone that Granthi is sending all the report of area to Desi Chodi, Kochi, such and such. He was also telling to the Granthi has written a lot about the cashew factory. He told about phone that Granthi is proceeding 10 p.m. to 11 p.m. to his house on motorcycle alone, and asked the receiver to finish him at that time. I can identify the Lulu journalist. Today, due to escort problem, the honor track do not produce in the court. They are printed such and such.
That's
Yes.
true.
Then so the recovery of weapon, the talks, and there is the identification in the TI parade, particularly the Marana. It's all circumstances, clinching circumstances. If the lordship will go through the entire judgment regarding the particularly these two persons, and moreover, having cases there in their name during pendency of the case, 3 cases, and that too by the way how powerful they may be, that they manage the police not to give this name. If the informant would not have been appeared, there was no reason for my lord friend to do
no criminal antecedent. That is given by the
If
I1.
informant would not have appeared, my lord,
Yes.
to assist your lordship, there was no reason. The plan was very successful, and my friend didn't have the occasion to know whether there's such any other case because he has to rely the
Right.
instruction to the police. So in this background, and because of because they are the author of the crime, and circumstances very clinching, all other people are there because they conspire. They are equally responsible, but since the during
three witness statements are very relevant in this case, and they are PW 10, PW 13 and PW 26. And so far as so far as PW 10 is concerned, he has not identified the petitioner in the doc. So far as PW 13 is concerned, it is stated that who accused P. Samsundar Reddy 4 to 5 days prior to the occurrence handed over rupees 50,000 to him as well as co-accused Santosh Maharana. But it is not stated for what purpose the money was given. So far as PW 26 is concerned, he has also not identified the petitioner in the doc. The Learning Council further submits that there is no criminal antecedent against the petitioner and there is no likelihood of the appeal being taken up for early hearing and therefore the bail application of the petitioner may be favorably considered. Learning Council for the state, on the other hand, opposed the prayer for bail and submitted that at the instance of the petitioner, 2 motorcycles were recovered from the house of the who accused and
It's night.
And the money which was handed over by P. their number Samsung. The money which was handed over by accused P. Samsundar Reddy 4 to 5 days. 4 to 5 days prior to the occurrence was to the present petitioner and co-accused Santosh Maharana was for commission of the crime, which should be which comes out from the statement of the said co-accused recorded under section 27 of the Evidence Act. That is 27 reference section 7 of the considering the Mr. H.S. Mishra, Grand Counsel, appearing for the informant, also opposed the prayer for bail and placed the evidence of PW 13 and PW 24 and submitted that since the petitioner has been identified by PW 13 to have received money from the co-accused P. Shamsundar Reddy. P. Shamsundar Pushti. He can be said to be a part of conspiracy to commit the crime, and therefore it should not be released on bail, particularly when there are recovery of motorcycles at the instance of the. Considering the submission made by the Land Council for the respective parties, the nature of
Motorcycle and knife also.
Some source. Yeah, motorcycles at night.
The nature of evidence available against the petitioner during trial, absence of any criminal antecedent, release of the co-accused persons on bail, and taking into account period of detention in judicial custody, we are inclined to release the petitioner M. Ramesh alias Narayan Reddy on bail, subject to condition that while on bail, he shall not indulge in any criminal activity. He shall not try to come in contact with any of the constitutional weaknesses. Violation of the terms and conditions shall entail cancellation. Now we come to the second one. Shantosh Maharana, CRL number 649 of 2019, IN number 1463 of 2009. Mr. Dhanam Mahapatra and counsel appearing for the petitioner submits that the petitioner is in judicial custody for about 9 years. No?
9 years, 6 months.
For about 9 years, 6 months. And the case is based on circumstantial evidence, and there is no clinching circumstance available on record against the petitioner. He placed the evidence of PW10, PW23, and PW26, and submitted that in view of the available material on record, particularly when the co-accused persons have been enlarged on bail, the bail application of the petitioner may be favorably considered. Learned counsel for the state, on the other hand, produced the report from the IIC Alipur police station, which indicates that apart from this case, 4 cases have been instituted. 4 more cases have been instituted against the petitioner. One of such cases was prior to the commission of the crimes in question, and 2 cases were instituted while the petitioner was in jail in this case, and the 3rd case is with the petitioner committed while on parole. Stop. The learned counsel for the state further submitted that the petitioner was an absconder for which charge sheet was submitted showing him as an absconder. And at the instance of the petitioner, one knife was recovered, and
he was arrested from Nagpur, my lord.
He was apprehended from Nagpur.
1 year
about 1 year after the operation, and he learned counsel submits that if the petitioner is released on bail, there is likelihood of his absconding. Therefore, he should not be released on bail. The custody certificate of the petitioner was produced, which is taken on record. Mr. H.S. Missile and counsel for the petitioner also to prayer for bail, same contention has been to be taken by, and he submitted that in view of the conduct of the petitioner in committing the crimes while on jail as well as while on parole, he should not be released on bail. Considering the submission made by the learned counsel for the respective parties, the nature of evidence available on record, the criminal antecedents of the petitioner, the conduct of the petitioner in committing the crime while on parole, we are not inclined to release the petitioner on bail stance.
May submit matters. May primaries. May primaries. May primaries only. May primaries. May primaries. Only 2 things may I point out. My bail petition has been rejected, maybe given a chance of renewal because of the fact.
You can apply for bail.
Well, thing is that during parole it was a 394. May submit matters. I may be permitted to only option.
There is no permission is necessary to file another bail application.
Well, because
I can argue item.
Item 11, may I please, my lord?
Please, your
My lords, here I was arrested on 8/10/2015, my lords, and I am in custody.
Evidence of agency from legible.
We have received copies.
Upon copy.
Yes.
I think legible copy or scanning is
Scan copy रहते ना हो? नहीं.
Definitely, police have to implement their own. All of the very clear. Scan putting on your report one of the you should content be taken off.
Can it be day after tomorrow?
Okay, then I'm but should be scanned. ତାକୁ ରିପ୍ଲେସ କରିଦବ ସେ ଯୋଉ ଏକ ଦୁଇଟା ଯୋଉ ଅଛି ନା ଦେଖାଯାଉନି ତାକୁ କାଟି ଦେଇକି ଏଦିଟା ପକେଇଦବ
Item 11.
May I please, my lord? Strength of prisoner petition, I am appearing, my lord. And petitioner has granted the interim bail on dated 19/4/2023, my lord. And there is also a interim bail, that is IA 1972/2024, my lord.
Just a minute. If you are granted interim bail on 19/4/23,
My lord.
For a period of 3 months.
Yes, my lord.
Then what happened?
Lord, they have surrendered, my lord.
Okay. Now you have filed another application for bail.
My lord.
What is your instruction? How he conducted himself when he was released and what is the period of detention?
Lord, his custody so far appellant 1 is concerned, my lord, the custody since 27/7/2016.
And the IN number has been, this interim application has been filed for both the appellants.
Both the appellant, my lord.
Okay. So what is the detention?
Have to take his license.
And a number, he was released on bail by the court by order dated 19/4/2020, both of them. So how they conducted themselves during that period, right? With that instruction on telephone, IN number
1972.
IN number 1972 of 2024. There is an application for interim bail of the appellants. The Land Council submits that the appellants were granted interim bail for a period of 3 months by order dated 19/4/23 IN number 1. And after availing the claim, they surrender at right time. Let the Land Council for the state obtain instruction as to how the petitioners, whether there is any allegation of civilization of liberty against the petitioner while on intelligence, and also produce the surrender certificate and personal certificate of the petition. Which is fixed to 27.
Which scale?
Oh, yearly. Business petitioners,
Korapur. Navarampur, my lord. Navarampur? Yes, my lord, Navarampur.
Petition would subject Navarampur. Okay.
Item 12.
Please. juvenile.
You were there.
Well,
At the Mahmoud.
my lord. Exactly.
Yes.
I will. Page copy.
Affidavit I have already.
Page but wrong information ଦେଇଦେଲା ଭୁଲ certificate ଦେଇଦେଲା big apology my lord.
ଆପଣ ଯିଏ affidavit କରିଥିବ ସେ ତା ଦେହରେ ସେ ଅସୁବିଧାରେ ପଡିବ ନା
first time
filing an application and making a claim that you are a juvenile, so the conviction be set aside. That is exactly your prayer. And
my
in
lord.
that petition you are annexing a fake document, a forged document. So obviously the consequence is to be followed. So देखिए आप लोग ऑब्जेक्शन में कौन लिखेंगे?
Page 2 of my affidavit, last portion. Yes, during verification of school admission register produced by the headmaster, found that no such student, namely Sanatana Hesa, son of so and so, had got admitted in the school from the year 97 to 2001. Copy of school admission register annexed here with annexure A. The school admission register was seized and so and so. On being asked regarding the genuineness of the transfer certificate submitted by the petitioner is annexed here with annexure C. The headmaster stated that no such transfer certificate had been issued in favor of Sanatana Hasa.
प्रेस कर दीजिए घरे प्रेस करिए नहीं ताकि वो नियरेशन की छपी रीजन से ओके लेफ्ट
No my lord. ଯାହା ସେ document ଦେଲା ସେ ଅନୁସାରେ ମୁଁ ତ good faith ରେ କରିଛି
this is 2788 of 2023. This is an application filed by the appellant, petitioner Jotto alias Sanatana Hisa, for reconsideration of the conviction order on the basis of age factor and set aside the order of imprisonment like passed by the running trial court, that is additional session judge Ralche in CTS number 26 of 2015 by judgment and order dated 4/12/2019. Grounds have been taken in the interim application that the occurrence took place on 7/12/2014 when the petitioner was only 15 years old and his date of birth is 3/8/1999 as per his school transfer certificate dated 17/8/2009 issued by the headmaster primary school. So also Aadhaar card bearing number so and so, which clearly shows that at the time of occurrence, the petitioner was a minor or a juvenile. The copy of the school transfer certificate and Aadhaar card has been annexed to the interim application as annexure 1 series. Reliance has been placed on the decision of the Honorable Supreme Court in case of Vijay Singh versus State of Delhi, reported in 2012, bracket bar 53, OCR, Supreme Court 592, where the Honorable Supreme Court set aside the sentence imposed on the accused enforced by the trial court and released the petitioner as the petitioner as the appellant was found to be the juvenile in that case. On 37/2024, when the matter was taken out, we the Land Council for the state filed objection to the petition, and copy of the objection has also been served on the Land Council for the appellant. To the objection, while the inspector in charge of Tarcher police station has mentioned, quote it from that page number
2, rural Nagpur, sir.
Roman 1 or she during verification of the school admission, the paragraph of Purat Roman 2 state of
3.
Roman 3 was
1, 2.
1, 2 and thus it is apparent that the petitioner that fraud has been committed on this court by annexing such documents to get the release. Stop. One Donardan Sethi, the advocate's law, has shown affidavit in this interim application. Notice we issued to the concerned advocate's law as to why the proceeding for contempt of court shall not be initiated against him for filing forged document before this court. Janardhan Sethi shall appear before this court on the next date, which is fixed to 22nd of August 2024, and at time at 10:30, and registry use of the Land Council for the appellant. Land Council for the appellant shall intimate his clerk to remain present on the date which.
দুইটা করে আমাদের সেকেন্ড নাম্বারটা
Item 13.
Right, please, Your Lordship. In this case, my lord, the appellant is in custody.
Yes. Yes.
The appellant is in custody since 29th of May 2008, my lord. It is about more than 16 years detention, my lord. And in this case, my lord,
no, we asked the State Council to produce the
Yes.
So, okay. What is the come to the straight judgment paragraph 2? Agu reject it lagi apan.
no, my lord.
Agu.
Yes.
IA 1011 of 2021 has withdrawn. I have noted it.
No application reject.
Okay. Please come to paragraph number 2
of the judgment, my lord.
Factor.
On 30th May 2000 at 8:35 p.m., the informant Surendra Behera, son of letter so Bhutia Sai under Lalbagh Police Station, submitted a written report before the inspector in charge of Lalbagh Police Station to the effect that on the same Tuesday at about 8:10 p.m., when he along with his deceased sister-in-law, Haramani Behera, and niece Nima Behera, were proceeding towards the cattle shed situated around the Satichura embankment, noticed arrival of an auto rickshaw on the embankment, from which one Bombi Jena, son of Kartik Jena, of Dogarpada, Gopal Sai, Kotak, along with one Sentu Jena, Gunga Jena, Kanu Jena, and Nazir, son of Lalmia, of Mohammedia Bazar, numbering 5 in total, alighted from the tempo, rushed near them when each of those persons was holding a sword having length 3 feet, and asked them about the whereabouts of one Hadia. By abusing this, that is a fact, my lord. I have filed an application under section 391.
Just
my lord, no, it is not there.
It's not there. Yes, tapare kon hala?
To that effect, 391 application is there. The culprit also asked the sister-in-law of the informant about the whereabouts of her son by addressing the lady as widow, and started assaulting her by the weapon of offences held by them. The informant, finding no other way, dragged the niece and got themselves concealed in the nearby bushes to save their lives. The sister-in-law of the informant screamed as Marioli, but sometimes thereafter she remained mum. However, the alarm raised by the sister-in-law of the informant said to have attracted the nearby people named Dilip Jena, Punya Jena, and others who rushed to the spot, but the assailants then went towards the embankment with the weapon of the offense held by them and decamped in the tempo by extending threat that the mother has been smashed and Hadia and Gedu would be murdered the same day. After departure of the assailants, the informant and his niece rushed near the deceased and found her lying bleeding on the ground. Anticipating the fate of the deceased on either side, the informant prayed the police to punish the culprits by investigating.
So, Haramani Behera is the deceased.
My lord.
You are not named in the FIR.
No, my lord.
You are not been charge sheeted. You
No.
said that 319
1991 application is there, my lord. So far as informant and eyewitness.
Charge sheet is
Charge sheet.
391 na 319?
391.
391.
No, 391 for additional evidence before the appellate.
We are not on that. We are. We thought that perhaps you were.
No, he has been charge sheeted.
You are charge sheeted.
My lord.
So, okay, FIR, your name is not there. As
No,
you
my
said. So, eyewitnesses have stated your name.
No, my lord. In a previous, it is a split up case, my lord. Before this trial, another sessions trial also disposed of in ST 31 of 2001.
ST 31 of
2001.
Okay.
And the ST 31 of 2001 also dealt with this judgment, my lord. At page 22 of the page 22. The internal page is 14 of the judgment.
20 internal page?
14
of
the judgment.
Yes.
I'm reading the relevant part. In this,
In the light of the submissions.
In this short evidence in the court, 6-7 lines.
6 lines. Top na bottom?
From top.
Top, 6-7 lines from the top.
In his short evidence.
In his short evidence in the court, he fully supported the FIR version, dated the occurrence, identified the accused, deposed about his arrival in an auto rickshaw with a sword along with 3-4 others, and the assault made to the deceased with sword. The specific allegation made in the FIR that he and his niece concealed themselves in the nearby bush. And then I would like to read out during cross-examination. Among other things, he was asked to have deposed certain statements in ST 31 of 2001 without involving the present accused, which he denied. But the learned counsel, in order to substantiate his submission that this witness had not deposed against the present accused in the earlier trial of the case, banked upon the observation made by their lordships, and so the decision. In that case, and so. And in her evidence also strike at the root of the prosecution case. But in the case at hand, the so-called statement of the informant, PW4, given in the earlier trial when confronted without production of the same before the court, otherwise till preparation of the judgment, was denied by the witness.
Additional evidence.
By annexing the testimony of eyewitness.
It is a fact that those very witnesses, when examined during the earlier trial, has not named the word.
No, my lord, that is there. Before your lordship in 391 application, I have annexed PW 4-5, and the judgment also dealt with that. The judgment certified copy of that ST 31 judgment also.
Procedure, but it should have been proved. 391 procedure. But you have drawn the attention of that witness. So Mr. Tripathi.
Yes.
So is it a fact that in the first information report, specifically it is mentioned that who are the 5 persons who came to this spot in different vehicles, being armed with weapons, and committed the offense? FIR. FIR has been lodged against 5 persons.
Yes.
One is Bambi Jena, 2 hela Santu Jena, 3 hela kono Gungo Jena, 4 hela Kanhu Jena, 5 hela Najir na kono. Najir.
Najir.
Najir, the auto driver. So, he accused na nahi. Yela gote aspect.
I may be apologize for that. One Jena is there, Bombi Jena.
Who is he?
But the present appellant is Sukuta alias Ashok Jena. So far as Jena is concerned.
No, it's all right.
No, that is how we are.
Here, his name is Baki Asipujanti, जो witness माने confront ହେଇଛି ପ୍ରଥମେ ଯୋଉ ଟ୍ରାଏଲ ରେ ସେମାନେ ସେ ଯୋଉ 5 ଜଣ ଫେସ୍ କରୁଥିଲେ ଟ୍ରାଏଲ ଫାଷ୍ଟ ରେ କେତେ ଜଣ ଫେସ୍ କରୁଥିଲେ
3 persons
ସେଠି ଟୋଟାଲି ୟା ନା କହିନଥିଲେ ଏଇ ଯୋଉ ସୁକୁଟା ଅଶୋକ ଜେନା ସେ ମଧ୍ୟ ସେ ବିଷୟରେ ସେକେଣ୍ଡ ଟ୍ରାଏଲ ଟାକୁ କନଫ୍ରଣ୍ଟ କରିଛନ୍ତି ଭୁଲ କଲେ ଏତିକି ଖାଲି ଏ ଯୋଉ ସାର୍ଟିଫାଇଡ କପି ଗୁଡାକ ଆଣିକିନି ଇଏ କରିନାହାନ୍ତି ଯୋଉଥିପାଇଁ ସେ 391 ଦେଇଛନ୍ତି ଏଇ ପରିସ୍ଥିତିରେ ସେ ରହିଲେଣି 16 ବର୍ଷ
Your Lordship, may see page 13 of my IA. That is the deposition of the informant and the another eyewitness, the niece of the informant.
No, so let him verify.
My lord.
Communication paper. କଣ କହୁଛନ୍ତି?
That is not there.
ବିଜେନା ମଧ୍ୟ
Is there?
ଓହୋ ସେଗୁଡାକ ଆପଣ he is otherwise called Bombijana. In the charge it is mentioned, right? तो ये जो witness माने जो earlier witness माने कौचंदी
नहीं बोले ले लोकर existence is not there. FIR, so far as deposition is concerned.
FIR ठीक है FIR से कौचंदी witness माने Bombijana ना कोई ना देखिए
4 and 5
PW4 कोई चीज देखिए
नहीं कोड कोई देखो PW4 in the IA रे page 13
ଆପଣଙ୍କର IA କାଇଁ
IA 1988 okay
1728 ना कौन नहीं तो
IA
what is your IA number
1988
1988
it was filed on 1728 निकले IA को तो
This accused face trial alone. अच्छा इतने PW4 तक आइडेंटिफाई अच्छा
ये जो annex करते document आपनकर entry marks दिए एटा जो earlier trial हो जा
my lord
अच्छा PW4 हो जा eyewitness
my lord
let us see
PW4 is eyewitness and 5 is the informant eyewitness
just factual aspect रे कौन सी भूलभाल हवा उचित है I know of the accused person standing in the dock. I know Swan, so the occurrence took place 1.5 years back. During the evening hour on 8 p.m. in the cow said Swan says, this is Haramani is my mother. On the occurrence daytime, I along with my uncle Surendra Vera and this is Haramani were present in the cow shed by the side of ring water. In the meantime, accused persons came in auto rickshaw. They got down from this one so came towards cow shed. While coming, they were abusing filthy language. They came and at first they asked my mother so and so. Accused Santu. Santu ki hai?
one Dilip Jena his
Santu immediately dealt a blow by means of a sword, which hit on the head of the mother, causing severe bleeding. The rest of the accused persons also got blows by means of sword on the mother. My uncle so-and-so out of fear took me so-and-so. The accused persons କହୁଛି ଆଉ ଆପଣ ତା ଧୀରେ ସେଇ ଆପଣ
This person is not present.
ମୁଦାଲା ମାନେ ସେ କହୁଥିବ ମୁଦାଲା ମାନେ ତେଣୁ obviously you are not present so cannot be said that he was not deposing against you. You
no in the present case she hostile in the present case she become hostile
a witness
well
देखियो present case lo देखिए
PW6
he is PW6
madam
या ना तो हमारा PW4 है अच्छा accused were not present at this poll among the convicts. I do not know अच्छा बाकी ଆଉ ଗୋଟେ जो
PW4
PW4.
PW4 is paid informant.
Surendra Behar.
In the this deposition, I am reading the cross examination.
PW4.
Yes.
PW4.
I know the accused standing in the document.
My lord.
This is Dharamani is my so-and-so.
My lord.
My deceased son got down in the auto rickshaw with his sword with 3 to 4 others.
Yes.
With the accused and all the persons assaulted the deceased with sword. That
I am going to cross examination. Around my cow shed, I had given fence. The said cow shed situated at 20 cubits away from 40 cubits away from Sathi Chowra Chowk. It is a fact that I have earlier deposed in the court in ST 31 of 2001 for the present occurrence. It is not a fact that earlier I have stated against Dilip for assault. Assaulting the deceased.
But
Is it specifically named in
number Saki
I got a PW5. Surendra PW5 hitla.
My lord. PW5 in ST 31.
The offender had found in the meantime auto rickshaw came. Even though stopped. Accused persons of reporting on from issue answer came there shouting from that is Dilip Jana alias Kentu dead and so I dead blows on the head of my sister in the same. So also the other 2 accused persons had towards one so dead blows by means of haram.
Change this out of
The posing is 8 days kola tasar out the jana.
3 persons faced the trial.
The other 2 accused persons, also the other persons, maybe, right. See, 3 jana was
And this has also been dealt with the judgment in that trial, my lord.
What about the criminal antecedent?
That is not short. I will take.
No, criminal antecedent twice your lordship sought for criminal antecedent. Once in 27 May 2022 and last occasion also.
Nahi kichi.
That I got the instruction, but so far as court sought for that.
All right. And the London Council for the petitioner and counsel for the state. This is item number 13, IR number 1728 of 2024. In pursuance of the order dated 24/7/24, the London Council for the state has produced a custody certificate of the petitioner, which indicates that he is in judicial custody for 16 years, 2 months, and 6 days. The same is taken on record. The Land Council for the petitioner submitted that the eyewitnesses to the occurrence have stated in a different manner than they earlier deposed in the case of the 3 co-accused persons who faced trial in ST case number 31 of 2001. And therefore, the petitioner has good chances of success in the case and balance of convenience is in his favor. We further submit that though paperwork has already been prepared, but there is no chance of early hearing. Therefore, the bail application may be favorably considered and counsel for the petitioner placed the evidence of the witnesses. London Council for the state opposed the prayer for bail, considering the submission made by the London Council for the respective parties, nature of evidence adduced during trial, period of detention of the petitioner in judicial custody, we are inclined to release the petitioner on bail subject to condition he shall not involve in any criminal activity and shall not try to come in contact with the family members of the deceased or any prosecution witnesses. Violation of any terms and conditions shall entail cancellation of bail. It is certificate taken on record for the custody certificate.
High Court.
Allowed. Appear before the local police or local police station. Once in a fortnight. On a Sunday, on every Sunday. Yes.
Item 13.
My lord, ID number 1277/2024 on
24 is read for instruction, my lord. With regard to
on the ground of ailment of the wife of the petitioner. Tomorrow.
Item 15.
Item 15 kindly taken up next week, my lord. I am not even able to go through the entire witnesses deposition copy, my lord. Taken up next week.
You have received the deposition copy, Mrs. Sahoo. Oh. That counsel for the appellant is for an adjournment to next week.
Next week.
Oh. With this matter, comments some 20th August.
Item 16.
My lord, kindly allow 1 week time.
Same.
Obliged.
Item 17.
May I please? On the last occasion, my lord, on 37 May 2024.
Just a minute, let us see that order. 3724.
Again.
Non-transferred for the prospect of the country also for the penetration. Regular petition has got to change system. Have to obtain and file a comprehensive appeal relating to this. What is your detention period? As per custody certificate?
9 years, 7 months, subject to verification. Okay.
So those two cases are one under section 392.
My lord.
And in which another case is 394/307.
Again.
तो कौन वाला से केस होता है
392 जो ओरिएंट पेश के समय 116/2014 रे सेदरे अक्यूज नु होटा इज नॉट द अक्यूज ब्लड मैं सेटा मु जजमेंट से लिखि 116 से इन्वेस्टिगेशन करथिले से आयो तापरे आकु अन्य केस ताकु धरले न काई जजमेंट एट पैराग्राफ 2
Oh, you have annexed the judgment.
Yes, sir. तादे ने आदरे एलसी अपील रे अछि तिल तुम अपील रे अछि
Wait, Orient PH case number 116. नहीं এটা তো আপন দেখেন 118
118 में आकुटेल हे ଯାଇଛି
हां সেটা তো 116 টা আপন অ্যাক্সেস
116 रे से जो इन्फॉर्मेंट जो केस प्रेजेंट केस रे इन्फॉर्मेंट 116 इन्वेस्टिगेशन कला बेले मते आउट केस धरले तादरे मते बुक करले जे सेटा 100 दैट इज पीएस केस नंबर 120 जजमेंट लिखा है पैराग्राफ 2 फैक्ट ऑफ द केस
कोथरे
जजमेंट
जजमेंट
इंपुन जजमेंट दैट अपील
इंपुन जजमेंट
paragraph 2 minute the fact of the case minute that on 12/12/14 the informant so and so of SIO police Orient PS lodged an affair before Orient PS alleging therein that conducting the investigation Orient PS case number 116 dated 8/12/14 registered 392 of the IPC apprehended so and so on 12/12/14 at 2 PM से इंडिपेंडेंट केस इन्वेस्टिगेशन कला बेले आकु धरले जो केस रे बुकले 3
केस से अपन एक्यूज ना
ना थे
ଆଚ୍ଛା ବାକି ଆପଣଙ୍କର ଆଗରୁ ବେଲ୍ ରିଜେକ୍ଟ ହେଇଛି
ଏଟା ୱିଡ୍ର ହେଇଥିଲା ଆଜ୍ଞା 12/10/2022 ନଟ୍ ପ୍ରେସ୍ଡ at this stage.
Bail application not pressed. Okay.
All right.
Custody certificate ଟା କାହିଁକି ଅଛି
Last time ଯାଏ
ଏଟା ହଉଛି 9 ବର୍ଷ ଏଟା ଡେଟେଡ କେତେ 30/7/2024 ଠିକ ଅଛି 9 ବର୍ଷ 7 ମାସ 18 ଦିନ ମାନେ 9 ବର୍ଷ 8 ମାସ ହେଇଗଲାଣି ଏଟା 30/7 so what is the allegation against you judgment page 2 ରେ आपको कौन ହେଲା paragraph 2 का question
yes madam that on 12/14 the informant Sri Kirti Kartikeshwar Shah SI of Police of Orient PS lodged an FIR before Orient PS alleging during conducting investigation in Orient PS case number 16 dated so and so registered under section 392 of the IPC he apprehended the appellant on 12/14 at about 12 noon while making personal search of Sanjit Gupta he recovered one pen drive of transcend model from his pocket on motorcycle big number so and so from his possession. The informant ascertained that the said motorcycle belongs to Tikanath Kalo. On verification of the contents of the pen drive, the personal data of Tikanath Kalo was found in it. He ascertained that Tikanath Kalo was missing since 8/12 by Manoharpalli PS case number so and so. The informant made interrogation of the accused Sanjit Gupta, the appellant. During interrogation, he disclosed that on 8/14 in the evening, he along with MD Ismail and Karthik alias Krishna Vaidya committed murder of Tikanath Kalo while committing robbery of his motorcycle and other belongings. At Ambodhara jungle on NS 49, he confessed that he concealed the dead body of the deceased at Ambodhara jungle in between Ambodhara jungle and petrol pump. On the basis of the information report, the written report Orient PS case number so and so dated so and so, and during course investigation, the IO examined the complainant, recorded confession statement of the accused under Section 27 of the Evidence Act, in presence of the witnesses, conducted inquest of the dead body of the deceased, made requisition to DHS Jharsuguda for autopsy of the dead body of the deceased, seized weapon of offense and wearing apparels of the deceased, accused persons as well as the deceased, and made requisition to SDGM Jharsuguda with a prayer to send the seized exhibits to Deputy Director RFSL Sambalpur for chemical examination. Visited the spot, prepared the spot map. After completion investigation, I have submitted the charge sheet against 4 accused persons, namely MD Ismail, Sanjit Gupta, Bode Babu, Karthik alias Krishna Vaidya, and Satish Vishwakarma, showing his absconded.
Case based on circumstantial evidence.
My lord.
And at your instance, the dead body was recovered.
Yes, my lord. On 27 recovery, the dead body is
material.
ତା ପାଖରୁ ମୋଟରସାଇକେଲ ଆଉ ସେ ଯୋଉ ପେନ୍ ଡ୍ରାଇଭ ଟା ସିଜ୍ ହେଲା
ପେନ୍ ଡ୍ରାଇଭ କଣ
that is your own belongings madam nothing about
ନାଇଁ ମୁଁ କହିଲି ଡିସିଜ୍ ର ପେନ୍ ଡ୍ରାଇଭ
this is a pen drive this is a pen drive motorcycle ମୋ ପାଖରେ recover
one is ଡିସିଜ୍ ର ପେନ୍ ଡ୍ରାଇଭ
ଆଜ୍ଞା
ଦୁଇ ହଉଛି ଡେଡ୍ ବଡି ଟା ରିକଭରି ହେଲା
ଆଉ ମୋଟରସାଇକେଲ ରିକଭରି ହେଲା
ଡେଡ୍ ବଡି ର ଯୋଉ
ଡିସିଜ୍
ର ମୋଟରସାଇକେଲ ମଧ୍ୟ ରିକଭରି
ଆଜ୍ଞା
Helmet of the deceased also seized, and the blood group AB of the deceased matches with the wearing apparel of the.
Oh, right.
That is dealt with Marat paragraph is the impugn judgment paragraph 6. The page 29 of the impugn judgment below the internal page. Page 29 and 30.
About the criminal antecedent.
ସେଥିରେ ମଗାଇଥିଲା ମୁଁ ଦିଲ୍ଲୀ affidavit ଅଛି
2 criminal antecedent I have also.
କେତେ ବର୍ଷ ହେଲା କହିଲେ
9 ବର୍ଷ 8 ମାସ
nature of stab injury throughout
The knife was recovered from the other co-accused, my lord, that is Kartik Krishna Vaidya.
Heard the land counsel for the petitioner and counsel for the state. The in portions of the order dated 37/2024, the land and counsel for the petitioner has filed a comprehensive affidavit relating to the status of two cases which were stated to have been instituted against the petitioner. In the affidavit, it is stated that in Orient PS case number 118 of 2014, the judgment has been pronounced and the petitioner has been acquitted. And so far as Orient PS case number 120 of 2016. 2016.
Yeah, 116.
Sorry.
Paragraph 2.
On 116 of 2014 is concerned, the petitioner is not an accused in this case. Rather, during course of investigating such case, the IO got the clue about the present case. The land counsel further submits that custody the petitioner is in judicial custody for 9 years and 8 months, and the case is based on circumstantial evidence, and the circumstances are not pinching, and there are good chances of success, and that therefore that application may be favorably considered. Land counsel for the state, on the other hand, oppose the prayer for bail and place the relevant part of the judgment and submitted that at the instance of the petitioner, the dead body was recovered. Who the dead body was recovered?
In the NH, my lord.
From forest. From the forest. And the pen drive and motorcycle of the deceased was also recovered at the instance of the petitioner. Moreover, the bloodstain wearing apparel of the petitioner was seized, and the blood group found on the wearing apparel matched with the blood group of the deceased. Considering the submission made by the land counsel for the respective parties in view of the nature of evidence available on record against the petitioner, while not inclining to release him on bail on merit, but taking into account the period of detention in judicial custody and absence of any chance of early hearing, we are inclined to release, and taking into account that Letty case, we are inclined to release him on interim bail for a period of 3 months. And the report has to be given about the conduct, and he has to surrender, and while on interim bail, he shall not indulge in any criminal activity. These are usual terms and conditions. Yes.
Obliged.
He has to file the surrender certificate after that.
Yes.
It